Hi, everyone. Together again. Thanks for joining me this morning. Want to see how many we have here. Hi, you guys. Hi, Georgina. Just waiting for a few people. We don't have too many in here yet, so I'm going to give it a little bit of time. Hi, Becky. Hi, Roll. Let's see who else is in here. Oh, hi, Linda. I know, long time no see, Allie. I did a quick drive-by over by Allie just to say I am here. I got about 4 hours sleep, so that's good. But I pretty much just rolled out of bed and came over here. Am I back on Facebook now? I will be back in my group again. Yes, I just probably take it a little bit slowly, especially after this. I'm probably going to need another break again after this. Hi, Sue. Yeah, my husband was giving me a hard time this morning because we keep locking Justice out of the room. And I said, well, it's hard. It's hard to do this with her wanting to my attention. I will say Travis should be joining me. I don't know when. I sent him the link, so he'll come in when he gets around to it. He loved listening to my daughter last night. Thanks, Janet. Yeah, we had a little bit of a rough start to that section, but I think it ended up pretty good. People just have to get to that if they do the rewatch. I said I'd like to be able to extract just that part of it and post it separate. Hi, Carol. Dogs are so needy, especially that one. Yes, but he told me I definitely owe her some time after this is done. She needs some mommy time. So I don't really have anything planned for today. I have no guests other than Travis. I shouldn't say that. That makes it sound like he's not a guest, but Travis is a given. And I have no topics in mind. So this should be interesting. Oh gosh, Roll, thank you for reminding me. I'm glad somebody reminds me because even I forget to do that. Switch your chat from top chat to live chat so you don't miss any of the comments. As of this morning, I didn't look in the last few minutes. Let's see what our totals are. We're just around $2,200, it looks like, total for this event. So that is amazing. Bring your dog in. We love dogs here. Okay, Ronald, that'd be great. So right now we're at about $2,200, and hopefully we can have a really big push this last 12 hours, 12 hours. I don't know if I should try to put another challenge up here today. Maybe if we're at 2,200, maybe to get to 2,500 by the end of this 4 hours. That might be a lot to ask first thing in the morning, especially since I was just pushing you guys last night. But again, the links to donate are in the description. And if you want to donate using PayPal, please remember to use the friends and family option if you can, so that there are no fees taken out. If you're international, there are less fees involved with using the GoFundMe link. And there is also the option to donate directly to Steve's trust if you would like to do that. We do not handle that. Mark Hodnott does, but he will update us with anything that has been donated to the trust when we are all through here. And that is money that is used for Steve's release fund. And he's the only one that can touch that. If he is not released, then it will go to his estate, whoever that may be. The rest of the money will be divided between the guys' canteens evenly. And Steve might want some in his canteen and some to go to the trust. We have to work that out once we have the final numbers. But Brendan said that all of his can go to his canteen. So everything helps. The fact that we've already raised $2,200 is amazing. These guys then will have what they need for a while. Anything they need while they're unfortunately where they are. Yes, be generous. Everybody has been very generous, so I feel like terrible even asking for anything anymore. But we're here for 12 more hours, and so we want to still keep trying to get more for them. And again, please, to continue spreading awareness about the case. Keep sharing. If you can't donate, that's fine. Not everybody has the ability to do that, but then please just share it. Share the videos today. Share on Twitter. Talk about the rally. I know the mods will post the link to the rally event page too. That's another thing that I don't think we've talked about as much as we'd like to, just because we don't have a lot of details at this point. I will answer that in a second, Russell. We don't have a lot of details ourselves at this point, but it's June 15th in Manitowoc, and we're hoping that this year will be the biggest rally yet. I mean, they really haven't been that big so far. The last one was about 50 people. I believe that in Madison they might have had a few more at that time, but it would be really nice to maybe double that amount this year. Let's get 100 people there. That would be great. It's really hard to get people to travel. It's expensive, but okay, Randall, I'll do that in a second too. It's really expensive to travel, and so we really appreciate people taking that time, especially when you have families, you have kids, to come and help support the guys, just to keep them at the forefront, keep them in the news, keep people talking, especially in Manitowoc. And that's one thing I will say, that we've seen that the attitude in the Manitowoc area is still not very favorable toward the guys, but we have changed some minds. We have opened some eyes. There are quite a few people that are in these groups on social media that have said that they are behind the guys and they live in that area. And it's not as many as we'd like, but we're getting there. Hopefully, the more information that comes out, the more that we spread awareness, that will get more people to start opening their eyes and actually just keep an open mind and look at all the evidence and maybe start rethinking things. Ronald, in order to donate to PayPal, if you have a PayPal account, I think you can donate using it. You can either connect your account directly to your bank account, and then there's no fees involved, but you can also pay by credit card. Hi, Scooby. I don't know much more to say about that. There is a direct link. My name is attached to that, and that's why we didn't want to post that, because we didn't want people to think, it says it's to the MaM-a-thon account, but when I set it up, I put my name, and I didn't realize that I couldn't change that. So, but it doesn't really matter. I mean, I'm the one that's going to be giving all the funds to the guys anyway. So you can, thanks, Sven just posted the direct link, and you don't need to have a PayPal account if you use the direct link. That's www.paypal.me/mamathon 2019. So there, if you don't have a PayPal account, you can just use a credit card, I believe, to pay that way. And we use GoFundMe for international donations just because they have lower fees than PayPal does for international people. Okay, I want to make sure I didn't miss anything here. And when we give these totals, yes, you can just click on the link that Fen just posted. The PayPal link right above you. You can click on that, and that's where you can donate. Yeah, so when we give our final totals, I just want people aware that the GoFundMe fees have not been taken out yet. I was taking a guess this morning, and I would say that they're probably going to be around $50 or so. So in the final total, when we show what's been donated, maybe is about $50 less. You'll know why. That's why. It's because of fees, not because anybody's taking a cut or anything. Thank you. Feel weird calling someone unicorn. Artie. Thank you, Artie. That's funny. I'm glad you're with me though this morning, Linda. I once again need to say thank you to, well, first of all, obviously the hosts for giving so much of their time. This is not easy. It is not easy to sit and be on camera for 4 hours trying to think of what to talk about and make sure you're trying to keep people interested. It's not easy to do. So definitely thanks to Allie and Paul and Eric Jose for giving up their time to do this. I don't think they think of it as a sacrifice at all. They enjoy doing it, and they definitely enjoy doing whatever they have to do to help the guys. But also thanks to Pom Pom, Julie, Fen, Linda, Denise, everybody that has been spending just as much time as we have. moderating. It is not easy, and you guys are the best. You are so quick with getting everybody the information, the links. I wish I could do more than just say thank you, that it's not enough. And people like Roll, who've been here, like, I don't know, Roll, have you slept at all? Because you've been here, I feel like, just as much as we have. Becky, you've been here so much. Jane, you too. I mean, so many of you have been here so much that I feel like you are sacrificing your sleep just right along with us. Eric, well, Eric, of course you're going to be here. I need to scroll back up because I had something I wanted to talk about and I forgot now. Oh, okay, I remember now. I am not a morning person, even on my best days. The only time I'm ever remotely a morning person is when I haven't gone to bed. And it's technically not morning for me. I did get, like I said, I got about 4 hours sleep last night. But even though I've been up, I've actually been up for about 2 hours, but I do not function. I am just not functional in the morning. You could give me 5 hours to get ready in the morning and I would be slow. Linda, you're excused. I think you're okay. You've been pulling your weight enough. So Russell had asked what the whole basically a lawyer thing means. And I know I've talked about this, but not, some people are new to the channel. It's obviously a joke. A couple years ago, I went to the very first crime con, and one of the items they were selling, some of the merchandise they were selling had the saying on it, basically a detective. I actually have a shirt and a sweatshirt that says that. I bought a sweatshirt and then I won a t-shirt. And, that's because the people that go to Crime Con are kind of true crime junkies. And so, it's just making fun of it. It's like, oh, well, basically I'm a detective, that type of thing. And so when I started my group not long after that, and I was just trying to think of what to call the group. I'm not a lawyer, but I think that when I first started doing what I do, I was mainly just kind of helping people understand what the document said, just putting it in layperson's terms. I wasn't really doing as much as like digging into the case law and everything. I just started doing that more as the need arose, as people started to be interested in that. Then I started just explaining more and more and more. So when I was trying to think of a name, what was that? Who's that? When I started trying to think of a name, my friend Angie, she came up. She's like, how about basically a lawyer? And so, there's Eric Jose. Hi. So that's what it was. And I'm like, hey, I like that. That's funny. Some people have made fun of it like that. And I don't get it because the whole point of it is that, no, I'm not a lawyer. And yeah, Roll, you're right. I do know a lot more than a lot of lawyers, to be quite honest. And so somebody had said once, oh, that's like saying, like putting a band out and saying, basically, I'm a doctor. I was like, yes, thank you. You get it. That's exactly it. Put an ace band into something like, well, basically, I'm a doctor. Yes, that's exactly it. So that is where the basically a lawyer thing comes from. And for some reason, people seem to not understand that it's a joke. It's very tongue in cheek. Yes, please like and subscribe. I would like to get to 1,000 subscribers just so that when we are at the rally, I can live stream on YouTube if I'd like to. Sure, Marty. Okay, Marty would like to know, can you give a layman explanation of where we are with the court filings and what to expect next?
Actually, I'm going to be here for just a second. I have a little quick clip to play for you before you get into that.
Okay, go ahead.
Hey, everybody. This is from Stephen, courtesy of the HOD. So here we go.
This is Stephen Avery. I thank you for supporting the MaM-a-thon. I hear it's going very well. I'm grateful that you care so much about Brendan and me.
So there you go, folks. Stephen's expressing his thanks about all the attention MaM-a-thon is helping to bring, and obviously the help we're giving them, him and Brendan. So wanted to share that with everybody because, the energy of this event is awesome. So I want to keep it going. So thank you for letting me come on and play that.
Well, thanks for bringing it on. It's very helpful to know that, that as we're doing this, the guys are thinking about us and thinking about what we're doing and are grateful for it and grateful for the supporters. So that certainly helps, helps us keep going in this final 12 hours.
Right? Everybody needs a little something to keep going, right?
Right.
So it's good to know Stephen appreciates it, that he knows. And so just thought I'd share that with all of you. I am now going to go get some breakfast because I've literally just woken up. So thank you for
anything. Oh gosh, don't even talk about food.
All righty. So we'll see you guys. I'll be finishing off the MaM-a-thon tonight. Crowning in quite a few guests, it looks like. So that ought to be interesting. So we'll see you then. And good luck, Tracy.
Thanks. See you later. Yeah, that was great. I'm glad he was able to play that so that everybody knows that Steve is very appreciative. I know that we've all said it. I've said it. I talked to Steve and I know he appreciates it, but it's really great being able to hear it directly from him as well. 2,300. So what did I say? 2,500 was a nice round amount. Good job, you guys. We're going good. I will get to the court thing in a second. How late does this go, the MaM-a-thon? We end at 9 o'clock tonight. And I just actually said before I came on that I can't believe that I scheduled our last hour during Game of Thrones. I said nobody's going to be watching. So I hope people will still tune in and just watch Game of Thrones an hour later. That's on me. Didn't really think about that. I wanted to think about what would be the best time, that most people would be able to watch. And a lot of people will be able to watch. It's just they'll probably be watching Game of Thrones. Julie, I don't think anybody's going to forget about it being on tonight. It's going to be a big episode. I don't know. Yeah, it's some people it doesn't air at the same time. So, well, I'm glad that's a good thing, Kimberly. So most of the time she's been awake during my time slots, and hopefully that's a good thing. That'd be great, Scooby, if you could come back. Yeah, I also have to say thanks to all the guests, everybody who's been on. We've had, I don't even know who's all been on. Allie just had Live from My Couch with Paul, and I really, really wanted to watch that one a lot, but I had to sleep. So but Allie, I'm going to go back and watch that because I really wanted to see that one. And I wanted to see when Seven Pop was on yesterday, and Jinx and Andy and TikTok, and there's just been so many great people that have been on. And like I said, I don't really have a topic, so some people are already asking questions, and that's great. We can just do that. Obviously, Travis will have stuff to add when he comes on. If anybody wants to come on to chat using the Google Hangouts, the mods can post the link, and you can come on and chat with me that way. If you want to get on camera, that's fine too. Okay, so before I forget which questions have been asked already, what is next for the case right now in general? That is that obviously right now it is in the hands of the judge. It is completely out of the lawyer's hands. Nobody can hand in any more responses, replies, any of that stuff. Nothing can be filed. Obviously, if you wanted to supplement with something like some last minute case law just happened, like a Supreme Court ruling somewhere, then you could supplement a citation, but I don't see that happening. What's it? What you're saying there? Yeah, Andy Newton and AC, two different people. So the judge technically has 90 days to rule, and it's even hard to say that because they technically can get another 90 days if they want. It should not take that long to rule on this. The Court of Appeals actually gave the judge 60 days on the CD issue, and they did not do that this time, which surprised me a little bit. It shouldn't take much longer. I did say this before that I am a little concerned because usually if the response is going to be, or the decision is going to be to grant a hearing, it shouldn't take that long to grant a hearing. A judge usually wants to get that down on their docket as soon as possible. So they don't wait 2 months to say, okay, I'm going to have a hearing on this. They usually within a week will say, we want a hearing. Now there might be a lot of issues that she needs to kind of evaluate, decide what, so it's not, it doesn't mean that there isn't going to be a hearing or that she's going to deny it. It's just that it does concern me a little bit. And it's not like it's not concerning already because this judge has not been very favorable to Steve, not very favorable at all to Steve to begin with. Now, what happens if there are a few things that can happen? If she grants a hearing then it's exactly that. They will schedule a hearing. At the hearing, the scope of it is limited to this issue with the bones. Now you can call witnesses. A hearing is kind of considered an extension of the actual trial. It is not in front of a jury, it's just in front of the judge, but there will still be like an opening and a closing, and you call witnesses, you subpoena witnesses, you put them on the stand, you do direct examination, cross-examination, and you can call anybody to the stand that has information that is helpful to the judge in deciding whether there is a violation here. Travis, now that you're here, can somebody keep track of the questions, because they're scrolling by so fast, and then I don't want to keep stopping midstream because you know how I am and I'll forget what I was talking about. So Mark, if somebody can remind me of your question, I'll answer it. So what happens is that, if you have the hearing, then the judge will take all of that information into consideration. A hearing is a fact-finding review. It's a proceeding. It is to get all the facts surrounding this issue so that the judge has all the information she needs in order to decide whether, yes, there was a violation or no, there was not. If the judge grants the hearing, they have the hearing, and she rules in favor of Steve, that is when that would result in her overturning his conviction and ordering a new trial. Obviously, it's great to hear those words. That is the long shot. That is the thing that we want to happen. But that's the thing that's, if you listen to my interview with Michael Cicchini, that is the rarity when it comes to post-conviction, is for somebody to be granted a new trial or get their conviction overturned. It is the slimmest percent of prisoners that get that opportunity. And I don't want to be like a killjoy or anything. It's just that is the fact. That is facts. Yes, that's my next point. Yes. So even if Steve wins, and you saw this happen with Brendan, even though the judge can say, I'm overturning your conviction, I'm granting a retrial, it'll be the same type of thing. We'll have 90 days to either appeal this decision or release him or initiate proceedings to retry him. Clearly, we know what the state would do, just like they did with Brendan. They would appeal the decision. And what would happen is that appeal then would probably be consolidated with the current appeal. I don't know if they would rule on that separately. It would seem that they would just do it all at once. It's just that it's a little confusing because the appeals then would be at different stages. The stuff that is right now in front of the appellate court, the question is, should there be a hearing? If Steve is granted a hearing on this issue and he is granted relief, well, then that's a different issue. Then they have to decide, yes, should we overturn his conviction? So that would be two separate issues. So I don't know if they would consolidate them or separate them. Not sure how they would do that exactly. It's an unusual situation, obviously. Usually you don't have two separate stages of a petition at the same time. If the judge denies it either before a hearing or denies it after a hearing, then Kathleen will appeal that decision, and that would definitely be consolidated then with her current appeal. That's why the Court of Appeals said they wanted to remand it for fact finding on this issue, because they already have all this other stuff in front of them to decide if there should be a hearing. So there's no reason why they shouldn't. Okay, let's get all the facts surrounding this out first in the trial court, and then if you deny it, then bring it up and we can evaluate that at the same time as we're evaluating everything else. Rosa keeps asking the term in and of itself means. I see it all the time in legal jargon. It just means including everything, including what I'm talking about. That's all it means. Yeah. Yeah, or that's what Julie just said it better. It's more like just by itself, it doesn't. I am terrible at trying to explain things right now, not in the morning especially. Yeah, in and of itself, that means by itself, it doesn't necessarily mean that. I think that's the best way to say it. I don't know. You say like that brief in and of itself is not enough, so you're just saying that alone. And yeah, I guess you could word it a different way. I just said two totally different meanings, but hopefully that last one will be better for you to understand. Again, don't function well in the morning. Okay, so now I need to go back to some of the other questions, and I don't remember what they were. Somebody said something about, was it Travis? Travis, were you asking something about the judge? Well, Mark, let's see. If I had a question about Casey's motion, she brought up the tire tracks in the gravel pit next to the salvage yard. As this is around the bones, why did she bring it up? And can Judge Suck ignore this part? Well, the judge can ignore the entire, or do you mean did she say that in the original motion? Yeah, I think she did in the supplemental motion. Yeah, the judge can take into consideration anything she wants. That is considered just tangential information to the actual claim itself. It's just saying that there is a reason to believe why these bones are significant, and because there were tire tracks found there, that means that somebody put them there, even though just logically somebody had to put them there because bones just don't like drop out of the sky. So yeah, so that's all. It's just additional information she's using to support the fact that these bones are important to Steve's case. That's all that it is. I hope that answers your question. I'm still going back to the other. I thought I missed a question in there somewhere. What reason? Oh, here's one. Yeah. What reasoning do you think Flowers will deny? You guys will notice that I do not use any of the little nicknames or anything like that. And it actually, like, it's hard for me to even comprehend when I read it. That's why sometimes I'm doing a double take. The reasons why she could deny it. She could pull out the procedural bar. She could pull that out because, and this is so frustrating, but again, if you listen to my talk with Michael, I mean, this is the thing he's talking about. A judge can literally just find a way to deny something if they really want to. They'll just sit there trying to think of something. These bones were disposed of in 2011. When Kathleen took the case, a lot of times what new attorneys do is they will file a motion for post-conviction discovery. So they make sure that they have everything regarding the case since the time the previous attorney has it. Now, there had really been nothing on the case other than Steve's pro se filings. So that may have been why Kathleen didn't file a motion for post-conviction discovery, because she just didn't think there was anything. She got the files from the previous attorney, so she thought that file was complete. And this is where that ruling on Brady, even though post-conviction is not considered Brady material, but this is where that ruling saying that who has the burden, the prosecution or the defense. In post-conviction, they're probably going to say the burden falls on the defense, that she should have filed a motion for post-conviction discovery. And had she done that, meaning had she exercised that due diligence, then she would have had that information about the disposal of the bones, and she could have included it in the original petition. Now, one reason why it shouldn't be barred, even if that's the case, is because this is, like I said before, this is still the same petition. This isn't an additional petition. This is still an extension of that first petition. But knowing how this judge is, she could try to say that. She could try to say that she is not filing this timely enough because that information was available in 2011. Because that's the other thing. Even though she didn't put it in this motion, she could have said, Steve should have included that in his pro se motion. That's where the procedural bar comes in. When Steve filed his pro se petition in 2014, was that? It was under appeal in 2015. Then he should have included that information. But again, Kathleen would argue, I wasn't on board yet. Steve didn't know that there would, so it's just a lot of back and forth garbage. Hi, Julie.
Hi, I was muted.
Okay.
I didn't know Travis was already here. I was just coming on to help you read questions. And then, of course, I lost my place in the chat. Hi, Travis.
Hi. Good morning, everybody.
We were worried about you yesterday when you weren't here.
We definitely were.
Let's see. Well, that's the big rule. Sorry, he's just saying you can't expect someone to include everything in a pro se motion, can you? And that's exactly what I said to Michael in our conversation. I said it is not unreasonable to say that it is unfair that a pro se litigant should be able to get all of the information they need to include all of their possible constitutional claims. It's very unreasonable to think that a prisoner would be able to do that. And yet I have never seen a court use the fact that it is a prisoner filing a pro se petition as an excuse to get around procedural bar. Never seen them do that. And that is punishing somebody for both not having the money for an attorney and for advocating for themselves. You are punishing somebody. When Steve filed that pro se petition, he had no idea that Making a Murder was ever going to be released. No idea. He had no idea that he was going to have one of the best, if not the best, post-conviction attorney decide to take his case on. He had no idea. He only had himself to rely on. And so he did the best he could. He tried to advocate for himself. Not very well, because he's not an attorney and he doesn't have as much information. And he is for all intents and purposes, he is being punished for that by saying you are now barred from bringing these things up. And it is incredibly unfair. But as we're seeing, the court system is not fair. It's not. Okay, Julie, sorry, go ahead.
No, it's okay. Vanessa was asking, do you think the Court of Appeals is not compromised, as is Judge Sukowitz?
Well, I'm not going to even say Judge Sukowitz is compromised. I think she's an idiot. Again, I'm going to refer to this conversation with Michael a lot, but he said the same thing. He said these judges sometimes are taught the law by the lawyers. They don't know the law as well as they should. I think that she is incompetent. I don't see anything that proves she's corrupt. Maybe she has a bias. It's hard to say because 99.9% of prisoners are ruled against. It's not just happening to Steve. This is the norm in a court. So there's no way to say that any other circuit court judge would suddenly be favorable to Steve when it is absolutely statistically that they would do the exact same thing. So I just want to clear that up. Like, I think just because we get an adverse decision does not mean that they are corrupt, but she definitely is either not knowledgeable enough in the law, or she doesn't care about the law, or she flat out sucks at her job. So what the Court of Appeals so far, there have been 3 decisions from the Court of Appeals. 2 in Steve's favor, 1 not in Steve's favor. The one that was not in Steve's favor was regarding the testing, and that was a proper decision because, as was explained, to do the testing is a separate procedural mechanism. That is not something that can be done under the 97406. And they stated that, once this appeal has concluded, she can file that motion to do the testing. So that was a correct decision, even though it went against Steve. The other 2 have been in Steve's favor. So I have seen so far no evidence of bias whatsoever from the Court of Appeals. Every ruling they have given, including the ones favorable, have been strictly based on the law. And that's what we want. Okay.
Bose says the statute does not provide remedy. So can the judge rule a violation without providing a due process violation needed for a new trial?
Well, one of the things Kathleen is pointing out in her motion is that no, there is no remedy, but if the remedy for violating this disposal statute, or not statute, but disposing of evidence is a violation of the Constitution, well, then the remedy is that a person's conviction has to be overturned. So she's saying under statute, then why isn't it the same remedy? Then it should be the same remedy. Why does it matter whether you're winning on a statutory violation or a constitutional violation? It's the same issue. They disposed of something that they should not have disposed of, and therefore she's saying they should be treated equally. Unfortunately, since there is no remedy, the judges could say, sucks for you, but we're not going to do anything about it, which makes it a hollow law. I mean, it is a pointless law to have then. Completely pointless if there's going to be no recourse at all for anybody that violates it. But they could do that.
Where am I? Marty McFly said...
Wait, hold on. I'm going to address this right away. It is not a conflict of interest for a judge to serve on a board with an attorney. It is just not. I need people to stop thinking that. Every time there is a board for something, they have people from every single aspect of the legal profession sitting on that board. Judges have been sitting on boards with attorneys since the beginning of time, and they still sit in each other's courtrooms. They stand in front of each other. It is not a conflict of interest, just for that. It is not. I'm sorry. I wish that it was, but it is not. You have prosecutors and defense attorneys who are arguing against each other sitting on the same boards. You have district attorneys sitting with judges, which seems unfair, but it's just that it's not considered legally, it's not considered a conflict. And most of the time it wouldn't be, because judges are supposed to be able to be impartial. And that's what the law says. The law says that these incredibly highly educated and highly trained professionals can be impartial. And the Supreme Court actually considers it an insult to say otherwise. That's why you cannot win on that claim. Okay, sorry, Julie. I keep cutting you off because I'll answer it.
That's okay. Maria said, but she went to school with Kratz too.
She went to the same school as Kratz. So did I.
Right.
Marquette University is a big school. It doesn't matter. You think about that. Okay, let's say how many lawyers graduated from that same class? Does that mean none of them can ever, go in? No, you can't. There are people on the Supreme Court that went to the same school. That doesn't mean that no lawyer that went to that same school or graduated the same year can go in front of them. These are things that I literally get so frustrated about, because I think people are just making up things when there is no legitimate conflict if you think about it in the big context. You think about it emotionally. Yeah, you think about it emotionally and you get mad, they serve together. They must be best friends. They must be in favor of each other. That is you wanting to look for something. And to me, that tunnel vision is just as bad as what the state does. That is you wanting to look for something to complain about, or look for something that's a conflict. There is enough without having to just kind of make it up. And I'm not trying to be mean. This is just my feelings on it. Okay.
That's one of the reasons. That's one of the reasons I wanted Julie to go over critical thinking and logical fallacies. There's been a number of people on both sides, but especially our side, that make logical conclusions based on people attending the same high school, living in the same county. This question is specific to attorneys and judges serving on the same boards. I served on the county bail bond board that had prosecutors, judges, county treasurer. We're all on that same board. I was on that board for 8 years. I sat on jury instruction board for the state to redo the criminal jury instructions. Everybody has a stakeholder, that's what you call them, a stakeholder on those boards. There's nothing improper or unusual, as Tracy was saying, about that in the least. And people just have to get over that if you're where you live or where you operate, Republicans and Democrats don't ever cross over socially, or whatever groups it is. That's just not the way it works in government and the law. We'd have an even more messed up system. They pretend to give us input as defense attorneys, but there's nothing improper about serving on the same board in the least. That's all I wanted to add on that.
Okay, and I'm going to just address this. First of all, Maria, you said if they're friends. Yes, if they were friends, if they have a personal relationship outside of the courtroom and are friends, then it could be considered a conflict of interest. But there's no proof of that. Going to the same school, serving on the same board does not mean they are best friends. Or that they're even close friends, or that they're friends at all. It doesn't mean that. That's what I'm saying. No, you might not be. And then Brenda said, no, you might not be looking for it, but you're making assumptions that they might hate each other. She might have thought he's an asshole in school. She might have thought he might have acted like an arrogant jerk when he went there. You don't know that. Marty, okay, he said, I thought when you went to Marquette, you didn't have to pass the bar. I actually thought about bringing this up when Michael was on, because he talks about this in his book. He went to Marquette University as well, as did half of our Supreme Court and some of the judges on the Seventh Circuit and many judges in the federal circuit. When you go to the Wisconsin School of Law or Marquette University, those two schools, There are extra classes you have to take in order to get your JD. You have to take extra classes that are accredited by the American Bar Association just to get your degree. It is a higher education than you would get at any other law school in the state. There are like an entire semester's worth. That's why you get immediate admission to the bar, because you are already, when you pass those classes, you are passing the information that you would be given on an exam. You still have to pass certain, and believe it or not, when people complain about Kratz, what's the number one thing? His lack of ethics. He still had to pass an ethics exam to get his degree, to get into the bar. Even if you go to Marquette, you still have to pass the ethics exam. So that makes it even less of an argument. And you will still have to be sponsored by a practicing attorney to get into the bar. So you can't get around those no matter where you go to school. But there are additional classes that are accredited by the ABA and approved by the Wisconsin Supreme Court. They oversee the curriculum. And that is why you are getting a better education. You are getting more education if you get a degree from those schools. So getting the degree means that you already have the information you need to pass the bar. Vanessa, I do not have tunnel vision. I am telling you the truth. I go by facts. There is no fact out there showing that Judge Suckowitz and Ken Kratz are friends. It is not a fact. So no, I don't have tunnel vision. I mean, I'm actually the opposite of that. Say, show them going out to dinner and hanging out for the night with their friends. Show me a picture of that. Fine, then I'll say, yes, there's a conflict of interest. How can you say I have tunnel vision when I'm saying that I am not going to consider anything that there's absolutely no evidence supporting? And the truth of the matter is, you don't like it. You don't like it. You don't like all of these things. That is not a conflict.
I don't think Tracy said that it isn't possible.
I'm not going to deal with this anymore. I'm not going to put up with it anymore. You are not understanding me, and that's fine. We can have a difference of opinion, but do not keep on and insulting me while you're doing it. Not going to put up with it.
So, do you want me to move on to something else?
I don't care. We can stay on the topic. It's like, just don't keep saying that. I'm not saying a judge is better than anybody. You're saying things that I'm not saying. I'm not saying a judge is better. I'm saying the profession itself, you are supposed to be impartial, and they are giving that the state, or judges in general, are given the benefit of the doubt that they can do that. You will, yes, that you will always have bad judges, always, but you will always also have good judges. You will have good cops. You will have bad cops. Vanessa, I apologize for that. I know you weren't insulting me, but it was just that it was coming off as like I was saying things I wasn't saying. So I apologize for using that word, because no, you were not. You are going to have good and bad in every side of this situation. Good attorneys, bad attorneys. It's just the nature of it. Good people in general in life, bad people. But yeah, and Stafford's saying, look at Hamilton. Hamilton's reasoning in Brendan's case is the most ridiculous thing I've ever read. Completely. Yet, this is again what I talked about before. You have judges who see things completely differently when they're interpreting the same laws. Like, how does that happen? And again, it's the nature of the beast. It's just how it goes. And Vanessa, I do apologize for that. I know that you didn't mean it that way, and I know that I didn't mean it that way. So I'm just getting heated. And, yeah, Maria, you keep saying Hamilton should be off the bench because you don't agree with his decision. There were 3 other judges in that circuit alone that agreed with him. So again, that's personal feelings. I don't agree with him either. I would love to see every judge that I don't agree with thrown off the bench, but that's not a reality. That's not fair. That's just like saying, I am not going into politics, but just in general, saying every politician that is a certain party or you don't like, they should not be in it. That's a personal opinion because you don't like them. That's all that is. And I get it. I mean, emotions run high, especially when it comes to something like this, because in general, and most of the people that I know that are supporters, we have this incredible sense of right and wrong. And to us, it is plain as day that this is wrong, completely wrong in every sense of the word. So how is it that our justice system can't see that and refuses to see that. And again, if you didn't watch when I was interviewing Michael, we talked about this very thing.
I just wanted to say something really quick. When you look at if a judge and an attorney know each other, or they went to the same school, or they served on a board together or whatever, it's one thing to accept that there's a possibility that there's some sort of collusion going on, and a completely different one to assume there is.
Right.
So accepting that it's a possibility is one thing, but assuming there is another. And I think that too many people are assuming there is, like, based on the fact that they went to the same school, they're both corrupt. Not necessarily. Let's look at this objectively. That doesn't necessarily imply that or prove it.
And as I said, you know,
that's the issue.
We talked extensively with Michael, who is completely like on the same page as us when it comes to the system, and he went to the same school. He got educated by the same people, the same classes, and obviously comes out with a completely different point of view. It's just, Maria, that is exactly it. It is frustrating and sad. That is it, on point. The judicial system is frustrating and sad.
I have a couple of old questions.
Okay, let's go. Yeah.
Before they get lost. Rule said, and I don't know if we're even going to remember the context of this, he said there are some counter examples to that assumption, Tracy. Kaczynski to begin with, impartial judge, ? But I understand that doesn't mean anything legally, still sucks.
Right.
So I guess that wasn't a question.
And I'm just going to address one thing with that. The thing that is kind of mind-boggling and even confuses things more is that Judge Willis did have some rulings that were in Steve's favor. So it's really hard to say, like, is he completely against Steve? Because if he was, then he would have allowed his criminal record to come in. He would have allowed that character evidence to come in. He would have done things that, you know, would have been even worse for Steve, but he occasionally did rule in his favor. And that's where I'm always like, there are things so obviously that were biased, you know, in favor of the state. And yet he did, you know, rule properly on some things. So I don't know. That's why it makes it confusing.
Well, your guest, how did he want to be referred to? What was his first name, your guest yesterday?
Mike. Mm-hmm.
Mike had a really good input comment yesterday. And if any of you didn't get a chance to see it, it's up, can be replayed and reviewed. I highly recommend, if you didn't get a chance to see it yesterday, to watch Tracy's interview with Mike. Very, very insightful. But one thing he mentioned, for example, the Denny rule, he referred to it as, you know, the third party rule in Wisconsin. That's where you're not only able to, as a defendant, say, not only was it me, I'm going to prove to you who it is. And he explained, you know, that was one of the things he wanted to cover in his book. But when he was talking about why he wasn't surprised on the way things turned out as a defense attorney, is that, especially with a murder case or a case like Stephen's first case, aggravated sexual assault, that on these defenses, like bringing a third person in, the judges, whether intentionally or subconsciously, they raise the bar even higher. And everybody's familiar with the 3 requirements, being able to get into, you know, bring in a Denny suspect. And that, for example, is the defendant would have to show the motive of this potential third party individual, whereas the prosecutor doesn't have to show motive. But he had this comment yesterday. I don't know if you remember it, Tracy, but if you do, if you could comment on it. He said, you know, with murder trials, and he talked about, you know, I've done a number of murder trials. It's very typical for the judges to ramp these difficult barriers up even higher to where they're even more difficult. nearly, if not impossible, to meet when you have a more serious offense. And it shouldn't be different at all. It should be the same. He didn't say this. This is my point. It shouldn't be any different. It should be the same for a traffic ticket as it is if you have a jury trial for a traffic ticket. It should be the same for a traffic ticket as first-degree murder or first-degree sexual assault. The principles of the law and the constitutional protections shouldn't differ. But I was wondering what you thought about his comment on that, that it seemed that the standards got even higher in this case.
Well, his biggest problem, and I'm apologizing because I tuned out a little bit because I was trying to comment in the chat and it wouldn't go through, and then it kicked me out of YouTube completely. And then I had to re-log in, and then I had to it put me in a different account. I don't know, something just crazy when happened. But you were asking about his feelings on the Denny rule, correct? That's where we were going with that.
Yeah, and that he said that he said, yeah, I write in my book, and he said, I have an article on my website. It's free for anybody to read if they want to read it. But he said, one of the reasons why I wasn't surprised by the outcome is in looking at the rulings, they seem to up the bar even more than normal. And he said, that's pretty common in Wisconsin when you have a murder case. And then you use the analogy, in this part of Wisconsin, murders not very often, not like murders in Milwaukee, where you might have a murder trial going every week. Here, a little bit different, and they seem to raise the bar even higher, according to Mike. I just wondered what you thought about that.
His main complaint about Denny, and this is what most people's complaint is the fact that you're required to show motive when a prosecutor isn't required to show motive when you're convicting somebody. And it is an unreasonable thing to ask people to do, because the reason why prosecutors aren't required to show it, and I've talked about this in my group, and I'll try to use the same type of analogy. When you're trying to establish motive is a frame of mind. Unless the suspect actually communicates to you what his motive was, you're just guessing. And the example I used in my group was, I said that a man could be on trial for murdering his wife. When you do the background on him, you find out that his wife was having an affair. You found out that he took out a large insurance policy on her. And so at trial, they established the motive that he killed her because she was having an affair and because for money, because for financial gain. And then, but in reality, this man was hearing voices in his head telling her that she was the demon spawn and murdered her because he thought she'd been body snatched by space invaders. Like, that is what I'm talking about. Like, you don't know that it isn't that crazy reason, but there are these other things that make it appear that it is his motive. But you don't actually know what his motive is, because that is a frame of mind. And unless he expresses that to you, unless he says that, like he needs a tinfoil hat because he was being told by space aliens that his wife was, a pod person, you have no way to know what his motive is. So what they're saying is, how is a person who is accused of a crime and for all, again, for all intents and purposes, didn't really know this person. He was, Steve was obviously, had contact with, Teresa before, but very little, and in no other context than as a customer, and someone providing a service. How is he supposed to know enough about her life to think of why somebody might want to kill her? That puts a very big burden on the defendant to find that information. And that's what he's complaining about. He's saying that, like, why should the defendant has enough of a burden proving their own innocence? Why should they have to take that extra burden on of trying to find out who killed her, on top, who actually is the guilty party? And so when they're saying you have to establish motive, they're saying that is too much of a burden, because how can you possibly know that? You just can't. You can take guesses. And that's exactly what Kathleen has done. She has said that this email proves that, Ryan was annoying Teresa, or that Teresa was sick of him, or he was eyeing her up. And you put circumstantial evidence out there that that would suggest what the motive would be, but you can't prove it. And so he's just saying that that should not be a burden that a defendant should have to carry. That's all that it is. And so he would like to see the Denny rule just be a little more, not have the bar so high as having to prove something that is actually quite difficult for anybody to prove. Not saying that there shouldn't be a third-party liability law, because there has to be, because otherwise you can just name anybody. You could go and pick somebody off the street and say that's the guy that did it, you know, and unless and without the guy having any connection to the person, the crime, you're just picking somebody out, and that's why they have to have some kind of rule. It's just in Wisconsin they adapted this legitimate tendency test. He also said in his book that even when attorneys seem to satisfy the test, the pattern has been that judges will still find a way to deny it. And that's why he said one of the things he's very anxious to see is what the judge does about Kathleen's third-party liability arguments, what they do with that eventually when they decide to rule on it. Hopefully that answers that question, right, Travis?
Maria had a question for Travis. What about Denny never actually getting approved for use since its original case?
It's always approved. I mean, that's the case law. That's the law.
That was the question.
Mm-hmm.
Are they saying that no trial court? We wouldn't know, I don't think, but are they saying no trial court has ever allowed a Denny third party argument? I
mean, I know that's not true. I mean, that they have, allowed third-party liability evidence in before, and I've seen the Court of Appeals overturn cases where they didn't let it in before.
I don't know if that's what she meant. I'm hoping.
I'm not sure what you mean. That is the law.
I think Tracy has said in the past. Tracy would know better. Tracy, has there been any cases construing Denny where like in Stephen's case, they argued that there was a violation on a direct appeal that he should have been allowed to bring in a Denny suspect. Has the court ever considered that? I thought you said they've looked at it a few times and they've never overturned a case based on Denny.
No, I only talked about that on bad faith. Bad faith was the one thing that I know for sure they've never ruled on. The circuit courts before have definitely granted Denny. It's possible they were later overturned by the appellate court, and maybe that's why Buting is saying that. But I definitely read cases where it's in the appellate court because of the alternate suspect issue, and I can't remember if it was because they're reversing because they allowed third-party liability evidence in, or if they're reversing because they didn't. But that would mean one way or the other. One court ruled in favor of allowing the Denny motion. And it could be that it was the trial court and it was later overturned. And that's why Buting's saying it's never been allowed. So that is possible. But I'm not going to say no trial court has ever ruled that way, because I know that's not true.
Real quick, I guess as an aside, Style Creator was asking if the donations are going to Stephen and Brendan's defense fund. And I know this is off topic, but I thought you might want to explain that really quick, or do you want me to just answer it in chat?
Yeah, no, they're going, the money that's being raised today is going into their commissary accounts, their canteen funds. For Steve, once we know the amount, Steve is going to decide if he wants a certain portion to go into his canteen and a certain portion to go into his trust. He's going to decide if he wants to split them or not. Brendan has already said that he wants 100% of it to go into his canteen. And then Steve's going to decide how much he wants to go in which place after we're done. But no is going to their defense. None of it is going to their defense funds. This is for the guys themselves, not for their attorneys.
Okay, perfect.
Could you add a little bit, Tracy? You explained when I saw the replay yesterday, you explained, could you take another couple of minutes and explain why it's really good for Brendan, especially for these canteen funds? What people kind of have a misconception of what canteen is, and because he's been moved to Oshkosh, right, there's a lot of really good things he can use them for, and Stephen too. But could you take a minute or two and explain that again to anybody who didn't hear it?
Yeah, the canteens in general are where, that is the store that is used in prison. And from that store, that is where the guys buy everything that they use. Their clothes, their toiletry items, their medicines, their envelopes that they use for writing people, all their, like, I said, pencils, pens, everything they buy is through Canteen. They can also buy some food that they can keep in their cell, things like that. Then they have to pay for that themselves. And obviously, I don't know what the going rate is for working in prison. It's like something like 14 cents an hour or something like that. So they don't, and it's not even working right now. So they don't really have any way of building up their commissary account unless people put money in there. And that's the only way they can purchase things. For okay, sorry, just reading that, Kimberly. For Brendan, he's going to be using a little bit more commissary money than normal because he was just transferred to Oshkosh Correctional Institution, which is a medium security facility, and that is good. Brendan will have more freedom of movement. He will have opportunity to more programs there. But one of the things that's different is that when he has visitors, they get their food from an actual restaurant that is run by the prisoners. And Brendan has to pay for that out of his canteen. It's not like before where people would go and we would, if you go to the prison to visit, you take change and you buy things out of the vending machines. It's not like that anymore. So now Brendan has to pay for his meals that he has with people when they're visiting. So that's going to take a little bit more from the canteen. Plus, Brendan has a tablet, and it costs money for him to get credits for the tablet. And with those credits, he can send emails. He can download movies, he can download music, he can download games, books, and he needs money in his canteen in order to do those things as well. So that's what the canteens are for. And this is why we're asking to help them, because it actually costs a lot for them to be able to do things that are, we take for granted, to get things and to be able to do things that we take for granted. And unfortunately, like I said, through a prison job, which actually neither have right now, you're certainly not going to make enough money to do that.
Okay, Sapper Cop says, I'm still confused as to why the Court of Appeals didn't flat out order a hearing instead of leaving as the judge's option. I don't think the Court of Appeals can rule objectively without a hearing.
No, that's not what the Court of Appeals does. Court of Appeals is not a fact-finding court. This is an issue where you have to have fact-finding. You have to find out, why were these bones given away? What was the reason for them doing it? That is what you have to find out. And that is a job for the trial court. That is not something. The appellate court is a review court. They review decisions that have been made and make sure that matters of law have been settled correctly. They do not do any fact finding. So no, they would not order. And the reason they didn't order the hearing themselves is because it is up for the judge to decide whether they need to have a hearing or if the matter can be settled on briefs. That's why that's up for the judge. They're not going to, step on. Now, if with the issues that are in front of the Court of Appeals now that stuff, they are now in review. They are reviewing that. And if they think Judge S should have ordered a hearing because fact-finding was necessary to make these decisions, then they can order a hearing. But they have to give the judge the opportunity first to decide whether it should be one, and then they can overrule her if they want
to. Russ says, do you think Judge Sekowitz may be persuaded from higher ranks, or do you think most of her findings are strictly from her?
Well, every judge is allowed to make their own decision. They can see things however they see fit, and this is why we have different levels of the judiciary. You have an appellate court to oversee these judges to keep them in check. So that's why, like, the appellate court has authority over her. She can't go against them if they order her to do something. The Supreme Court has authority over the trial judge and the Court of Appeals. They are the highest authority. That's why we have different levels. So when she is looking at something in her court, she has authority, but when that is subjected to, that can be subjected to review under appeal, and then they can change, they can rule differently. She can't change a Court of Appeals decision or a Supreme Court decision, but they can. Did you guys see what Kimberly just put in the chat? Can you guys read that, please?
I was just going to say that.
Okay.
No, go ahead.
It scrolled off my screen.
Oh, yeah. So Kimberly said that if we can get the donation total to $2,400, she will donate $100 to get us to $2,500. Right now, we need $174.81 to get to $2,400. So if anybody wants to, I'm sure Linda will have those links up in about 2.5 seconds because she's amazing.
She is amazing.
So if you guys want to, if you can donate, that would be great. And thank you, Kimberly.
Yeah, that is an amazing offer, Kimberly. Thank you so much. That is amazing. So who can help Kimberly out here and complete this challenge with her?
Absolutely. I think that's wonderful. Okay, so Russ also asks Tracy, how do you think the case with Stephen would have turned out if the trial was held in Eau Claire or Madison? Did I pronounce that right? Eau Claire?
In Eau Claire, yes.
Okay.
Eau Claire, Eau Claire is still considered like a smaller county. I don't think he would have had I mean, it could have been different. It would have been better than Manitowoc and Calumet, that's for sure. Dane County, which is where Madison is. He could have had a decent shot there. I personally think his best chance would have been in Milwaukee County. Milwaukee County is where we have more of our underprivileged society in Wisconsin. You know, there's more underprivileged people that are more peers to Steve, where, you know, they are used to being oppressed by police or feeling like they're oppressed by police. We're feeling like, you know, it would not take much to convince a jury in Milwaukee that a cop would plant evidence. They believe it as is, you know, so I think that's where Steve would have had the best chance because they're definitely more anti-cop, anti-establishment in Milwaukee.
Oh my gosh, I cannot math. I am not done with my coffee yet. We only need $74.81, not $174. Thank you so much, Kimberly. I'm sorry, guys.
No,
sorry,
that's
Tracy.
great. That's great news. I have always agreed with Tracy's assessment especially with regard to Milwaukee would have been much, much better. And then I also think Madison would have been much, much better in that you would have had on average, higher educated people in Madison be able to understand some of the smoke screens and to doubt some of the forensic evidence. I think they would have understood what limited amount of evidence and arguments that Buting and Strang did make on blood and bones. I think a more educated jury would have been more receptive to that. But so that consequently, that's one of the decisions I really question that the original trial team had was they wanted it moved to Calumet County so that there was no conflict with the jail personnel, but they actually moved a Manitowoc jury into Calumet to decide the case, which I've never heard of before. And in any other case, let's move everybody over another county because we can't trust the jailers to be unbiased and fair. And if you were going to move it, why not move it? But then again, maybe they knew where it would be moved would be incredibly worse. Tracy, do you have any more insight on why they didn't make an outright change of venue move? Was that
they did originally, and then I don't know the reason why. Then Buting and Strang withdrew their change of venue, and they agreed to just move the location to Calumet so that the Manitowoc County Sheriff's Department did not have access to the jury and to Steve, but they agreed to keep the jury in Manitowoc. I do not know why. I do not understand that decision. Dean Strang said that it was because they felt like he could not get a fair trial anywhere in the 72 counties in Wisconsin, and I do not agree with that at all. Okay, I'm going to address something because they're talking about it right now. Somebody asked, I can't remember, if a state case can be moved to federal court. When you lose a state case, you can, if you've exhausted all of your state options, you can petition for direct review to the U.S. Supreme Court. It's rare because it would obviously very rarely ever be granted, but you can. That would have been an option for Brendan. Brendan could have petitioned for review directly to the Supreme Court, or he could go to federal court on a separate procedural mechanism, the writ for habeas corpus. He chose the latter. If he had chose the former, he probably would have won because there would have been no EDPA rule involved. on direct review. So it is possible, but obviously it doesn't happen often because, I mean, the Supreme Court hardly takes any cases at all, and they really aren't going to take a state case unless it is something that is a matter of law that they really feel like needs to be addressed. So it's possible, it's just rare.
Okay, I have a couple of questions that are related to what's going on in the court right now. But this is an older one. Bose says, if the judge rules there was a violation of statute, say too bad, no remedy, can that decision still then be appealed?
Yes. Yes, because ultimately that is something that would be reviewed, and that is a situation where it could be appealed and reviewed by the by the Wisconsin Supreme Court because there is no remedy. So if that decision ended up getting appealed and they petitioned for review by the Supreme Court, that is a situation where they would probably review it because there is no remedy and that needs to be established. And so the Supreme Court would need to establish new law on that. So that is one situation where the Supreme Court would maybe take something, an issue in Steve's case. Yeah, yes, Eric, that's what I'm saying. The state, can the states, no, the state, well, yeah, technically the state can also appeal. I think they can also file a petition to the Supreme Court as well if they wanted to. Again, it's like rare that would ever happen. They would rather just probably retry it, but it could.
Okay, so we need $2.81.
Come on, you guys. I know you can
reach $2,400. Okay, so interrupting. Just
you can interrupt when it comes to that anytime. That's what we're here
Yay! For. Oh, and Fen just posted it in chat. I'm sorry, Fen. So Rule has said, I lost Brady violation count. Do you have a wrap up for that?
How many total Brady violations has Kathleen asserted? Is that what you're asking?
I think so.
It's it's at least 50. I don't know. I haven't counted in a while, but it's at least 50, I think.
It's a couple.
Yeah. A lot of them.
Oh
no, wait, not Brady violations. Wait, Brady violations. Well, yeah, no, there's not that many I'm sorry, there are not that many Brady violations. I knew the count at some time, wasn't it like somebody asked me this. I was thinking of ineffective assistance of counsel claims. That was how many she had, like 50 of those. Brady, was it like 11 or something? I counted them that one time, and I'm just totally drawing a blank right now.
Travis, do you know?
8, is that what it is, Jane? Okay.
The ineffective assistance of counsel.
Well, that was what I was originally thinking of by accident.
Way more outnumber the Brady. The Brady is it's less than a half a dozen, but it's the computer disk and boy, what a good quiz. The computer disk came up later, was added. I
got it. Before anybody continues, it's 7. I looked it up, my answer in the group. The state withheld the zipper voicemail. The state concealed the amount of gas that was found in the RAV. The flyover video was edited. The state failed to disclose that they believed that the RAV4 was driven on the Remand property. Colburn failed to disclose his conversation with Kevin Ramlow. The state concealed Ryan's connection to the crime scene via the day planner page, and the state concealed the CD containing the investigative report analysis of the DASI computer. That's all 7.
Okay, and without talking about the relative merits on each of those 7, Tracy, what would you consider the best one out of those 7?
Well, without having any additional fact finding, I certainly think the day planner to me has always been the thing that was like, you need to figure that out because he shouldn't have had that. But now, again, I'm just saying fact finding. I think the gas thing is going to get thrown out. I don't think that is going to do anything. The voicemail, the zipper voicemail, they're going to say that was an inadvertent error, that they lost it, nothing they can do about it. That's going to go nowhere. The flyover video was edited. Again, that might be for fact finding. And until they actually do that, I don't really have an opinion on that one way or the other. They failed to disclose that the RAV4 was driven on the Redoubt property. Colburn failed to disclose his conversation with Kevin Ramlow. Well, that is a he said, she said type situation. So that is going to be a tough one to win as well, because they have to prove that that happened. Then the day planner page, which that's one of the things that I think you definitely should have a hearing about. and then the state concealed the CD. And I think that issue needs to have a hearing as well. So that's my thought.
Hey, Tracy.
Mhm.
7 Pairs of Panties just pasted a screenshot of an email to Ken Kratz about making sure that no one but Willis would hear the case. She posted it in Discord. If you can go look at it, because I could link it in the chat, but I don't think everybody will be able to see it because it's a
Seven
Discord.
Pop, is that what Case Files Reviewer was referring to yesterday? He was referring to an email that I didn't know which email he was referring to. She's on right now, I think. I am not actually on Discord right now. I'm gonna have to. I don't even have a link.
Oh no.
I know. I don't know how I don't. I just don't. Let me just get there. I don't have a direct link to our Discord.
Well, I can paste the photo in our chat. Whoops. On Facebook. I just don't know if I can paste it in YouTube chat.
Yeah, I don't know how to do it either.
Yet. Okay, so I put it in our Facebook group chat, so you can see it.
Oh my gosh, I cannot. Oh, hold on, I'm looking right now. Where did you put it?
In our Facebook MaM-a-thon chat.
Oh, sorry, I went to the Hangouts one. Okay.
Sorry.
No, you said it. I just didn't hear it right.
It's okay.
Okay, let me read it real quick. Dear Mr. Kratz, the prosecution has filed a motion asking that the physical location of the trial and the reference case be changed to Calumet County. It is my understanding that the defense may join in this request. You have asked that I provide a statement indicating how Manitowoc County views the proposed change in the location of the trial. To that end, I have spoken with the county executive, the clerk of the circuit court, the sheriff, the comptroller, and the county clerk. The purpose of this letter is to provide the county's view of the proposed change in the physical location of the trial. Let me begin by noting that Manitowoc County believes that it is in the best interest of the county and its citizens for this case to be heard by the Manitowoc County District Court and by Judge Patrick Willis. We believe that is essential that there not be any change in the judge presiding over this case. Yeah, that is interesting, because for them to say that Manitowoc should retain jurisdiction and that it should be a Manitowoc County judge is one thing. To say it has to be specifically that judge is highly suspect. You know, they can say they can request a judge, but saying that does not sound proper at all. Well, Travis, what do you think about that?
What's the date of it? Who's this to? And who's it copied on?
It doesn't. I don't know who this was to. 7 Pop, are you still here?
She was just commenting, so I believe so. We just got some more donations with GoFundMe. I'm updating it now.
Okay, awesome.
It doesn't say who it's to.
Well, it doesn't in the screenshot. I'm just seeing if 7 Pairs of Panties knows more information about it.
But at the beginning, the context of it says, we believe the defense will be joining in this argument as well. Read that again.
It's asking. She said that it was to Kratz, and then asking who was it from.
Oh yeah, it was to Kratz.
Yeah, it's to Kratz, but I don't know who it's from. Yeah, I don't know who it is, because he's referring to how he believes the defense. Let's see. He just says it is my understanding that the defense may join in this request. So I don't know who sent this. Did she answer?
And it's to Kratz. Did I hear that right?
Yes.
To Ken Kratz?
Yeah. It's to Kratz, but I don't know who it was that was sending it to him. That's cut off, so I don't know who it originated with. Okay, so here's a Penny says she doesn't know. That's all that she's seen too. It's someone from Manitowoc, obviously. Yeah, somebody outside telling the special prosecutor that it's better to keep Willis on the case is incredibly suspicious.
Yeah, this it means nothing. I think what it is, assuming it's even legitimate, let's just assume that for a second, that it's even legitimate. And this is not a comment about 7 Pop or anything like that. You know, I just don't know the background and where it came from. But let's just assume it's legitimate. It sounds to me like it's county, whatever you would call it, the people who are in charge of the county facilities, the buildings, and it may be an arm of from what I understand, the courthouse is in the city. And so city police have jurisdiction of the streets that surround the courthouse. And then the sheriff's office has jurisdiction for court security. They sure marched over the defendants between the courthouse and the judge. It just sounds to me like it's a county official.
Yes, that is, it's coming from a county official because he's informing them of the county's position on this.
And then getting, you know, providing input to the special prosecutor about how to handle logistics in terms of courtroom security, things like that. They probably didn't know it was improper to mention who's the judge or whatnot. But the bottom line, which is I think where Tracy was going, Ken Kratz had no influence, input, or anything to do with the selection of the judge or whether that judge was going to continue.
Why this is suspicious is because of the last two lines. It says that it is in the best interest of the county and its citizens for this case to be heard by the Manitowoc County District Court and by Judge Patrick Willis. It's actually the last line. We believe that it is essential that there not be any change in the judge presiding over this case. That is what is suspicious.
Yeah, but it's to Kratz, so maybe it's somebody telling Kratz that if somebody tries to recuse Judge Willis, that he should oppose it. But
if it's above board, then they're saying it. Then you know that it should stay under a Manitowoc County judge. It shouldn't be naming a judge and saying it's essential. It stays with that judge. To me, that is what I find suspicious. I agree that we need more context, probably, but to make any real decisions, that's why I'm saying I think it's suspicious. Am I going to say it's corrupt? No, I don't have enough information. I'm going to say though that I would definitely do more fact finding on that particular statement and why it was made, because to me, saying that it's essential that they keep that same judge is to me a suspicious statement. Now, there are times when, again, if it's internal, like if Kathleen Zellner, I know Kathleen Zellner wants a certain judge on this case. If she wrote an internal memo to one of her people and said, it's essential we keep this judge on this case, that is a context where she's saying this judge would be favorable to us, I believe, or she's the best chance we have. So this could be a situation like that, where they're just saying, based on our position, he's the most favorable judge for us. But it could be taken in the context of there being some shadiness, saying it's essential he stay because he's in our pocket. It's essential he stays because, like he's going to rule in our favor. That is a possibility. And that would be why I'd say you need more context or you need more information, because it was like we were talking about earlier. You have to keep an open mind that it could be completely innocent, like I said with the Kathleen, analogy, or it could be we need to keep him because he's one of ours. It can go either way, but it's definitely, that's why I say to me it's suspicious, but I wouldn't flat out say it's corrupt or because there is a possible innocent explanation for it.
So it could even be from Fallon to Kratz, just talking about
county official, because he's representing the county's perspective on this. So it has to be a county executive. I think he mentioned the county executive. Maybe do they have a mayor? I don't know what they have there. It would be whoever he talks to the county executive. So it's somebody in that area. It's a county employee, obviously, or a county official. For sure.
Would it be the county attorney?
It could be. We don't know. That's the thing. We just don't know.
The same attorney that contacted the coroner and told her, don't go out there. You don't have any authority. That, they seem to be intermeddling in stuff that they normally wouldn't intermeddle in.
Right. And it said, is it a matter of saying it's essential because we just believe that he's a judge that would see things favorably, or is it's essential because we know he's going to rule in our favor? There's a big difference. Like I said, Kathleen wants a certain judge because she thinks she has the best chance with her for whatever reason. But you know, it's different if she says, I want this judge because we have a backdoor deal and she's going to rule in my favor. So it can be taken either way. It's just that it would definitely be something that would need to be explored.
Hold on. So as a comment to what you're saying right now, Real Crime Story says, so if Kathleen says that it's automatically assumed there's no improper influence. However, if some unknown county guy says that it's suspicious.
Why do you come in and just start arguing with people? Didn't I just get done saying it's the same situation with Kathleen, whether she wants it favorable because she thinks that person will rule or could be favorable to her, or if because she has a backdoor deal with her. I just got done saying that.
Right.
My God, stop coming in and trying to cause arguments right away.
I'm sorry, I wasn't trying to bring attention.
No, not you. I mean, obviously him.
No, I probably shouldn't have read it though.
I was reading it as you were doing it, so I would have said the same thing either way. I literally just got done saying that.
So I asked.
You're trying to argue with me because I made an analogy that wasn't complete enough for you. I mean, I'm just saying, stop being so argumentative about everything.
Oh, I think he's saying that you clarified it after he
posted
posted
it. That's what I was responding to, though. I was saying, though, but still, there was no reason to, you know, I mean, you're automatically making it into an argumentative or a debate, an argument. And that's what I have an issue with. I'm trying to just give a general analogy. Don't always assume that I'm saying, oh, it's only means something if it's the estate and doesn't mean anything if it's Kathleen, because that's not how I think.
Not today.
Yeah.
So I asked this earlier, and I don't know if I didn't ask it correctly, but KW is asking as well. So if Judge Suckowitz orders a hearing, not a trial, a hearing, can the state appeal that decision?
The actual decision to grant a hearing?
Yes.
No.
Okay.
Because that's what they sent it down for her to do, in part. If you read the order of remand and stay, some people have misread it that it's ordering Angie to conduct an evidentiary hearing. It's not. It's ordering it to be sent down to her to, one, allow Kathleen to file a supplemental motion, which she did within 14 days. It left open whether she wanted, you know, they didn't order her to accept a response and a reply. That would strictly be up to her, but Tracy already covered that yesterday. And it ordered her to make any determinations and factual findings she deems necessary. So conducting an evidentiary hearing would clearly fall within the part of that. And if she ordered an evidentiary hearing, the state would have no way to appeal that to the Court of Appeals. They would just have to engage in the evidentiary hearing. Then she would make findings of fact. Both sides would submit law, and then she would make conclusions of law based on the facts she finds. And then that, depending on how it came out, would join the appeal that's already on file if the motion was denied. If they grant her motion and give her a new trial, then the state's going to appeal it, and it's going to go back up to the Court of Appeals. But that's really a good question. Her ordering a hearing could not be appealed by either side. So you agree with that, Tracy?
Right. Yeah, no, that's why I said that they can't, because that is what the function of them to do is to fact find. So they can't appeal. Like, we don't agree there should be any fact finding in this case. What they can appeal is after the hearing, whatever the decision is. So, and yeah, I'm going to address that, Vanessa. I say, okay, like, not get head bitten off. I'm not biting anybody's head off. I mean, it probably comes off that way because it's like this went on last night and I see it happening already today. It's that there are people that sometimes just are looking for a reason to jump on somebody. And I felt like that's what that comment was. It was making an assumption and jumping on me because, like, saying that, well, I'm only thinking this if it's a state, but that I'm biased, that I wouldn't feel the same as Kathleen. And that's not what I said. And I do take issue with that because I feel like I try to be as impartial as possible. I try to keep both sides honest whenever I'm discussing the law and issues. And yes, I happened to clarify it after the comment. I didn't realize that, but I don't like the assumptions are being put out there that anyway, that I am biased, and I don't feel like the rules should be the same for both sides, because I feel like I have always been like that. I have always called Kathleen to task for the same things that I call the state to task. I've always told supporters, it's like, you can't complain about something just because it's something we like and then bitch about it when it's something that goes against us. You have to be at least fair in your assessment that way. And I have always done that. So that's why I get a little touchy about it, because it's like you're purposely trying to challenge me on something that I have always gone out of my way to make sure that I'm very fair about. That's why. And people getting their heads bitten off, like, you know what? It's, like I said, tensions rise, whatever, you know?
Dark Side of the Mood wants to know if you've ever met Kathleen.
On top of that, I'm sorry, but part of the problem is that, and I can't remember which logical fallacy this is. Maybe Julie can remind us. It's so if KZ says it, you know, first the person would have to flush that out, because that's suspicious right there. So if KZ says it, and I think what they're referring to is about the recusal. And I don't agree with the premise. The way KZ talked about the recusal in the supplemental motion, and then again in her reply to the response, is completely different than the way that we're talking about substituting a judge or replacing a judge in the context of this letter that was just mentioned. They're apples and oranges. And so that's why you need to be able to apply critical thinking in legal documents and legal arguments. If you lump them together when they're completely different, you end up in big trouble in terms of the effectiveness, the efficacy of your arguments in the appropriate court and at the appropriate level, and how they and in the manner in which you're able to carry those arguments through up to the highest level of appellate court that you can. But to me, there's a few problems. One, the example wasn't explained very well because it used the word it, and that if it's the recusal motion, it doesn't fit in this case at all. It's a poor analogy.
Okay, before I forget, Andy, Scotch Andy, I just want to say thank you for your donation yesterday. Like I ended like right when you said in the chat that you had donated. And so I just want to make sure we were like, oh no, we didn't get to say thank you. So I want to say thank you to Andy for your donation yesterday that we got cut off.
Julie, do you have updates on that number where we were at to get the?
Like, it's okay. Like, hold on, Vanessa. It is okay. Like, I'm not. I said it happens. It's no big deal. Like, I'm not thinking you're attacking me or anything. It's totally fine. And it's nice that you like people to stay calm. I wish I could stay calm. I'm bad at it sometimes.
Well, you know what? This case makes us we're all very passionate about this.
Yeah.
And emotions can get to us sometimes. Travis Finn actually just posted the total right now. We're at $2,612.19. Y'all are so amazing. Stacy Seabrook is in the house. Good morning, Stacy. And I personally think that we could get up to 2,800 before your segment is over, because I know how awesome these people are. And I have a question that Carol has been waiting to have answered for like 20 minutes. No, it's totally fine. I haven't been able to ask it because you guys are talking about such great stuff. So she said, I understood there was 90 days to make a decision/ruling. Where are we in those 90 days?
You do know I haven't slept much, right?
I have the answer, and I could link it. It's work with KZ.com, but I wanted to give you because this is your channel. This is not, I don't want to plug myself.
It all came from you, Tracy. Tell them about the judicial conduct rules is where it comes from, and explain to them how it works.
Well, I think I didn't really go too much today. Yesterday I talked about it. The rules are that you have 90 days to rule on a motion in front of you, but a judge can take an additional 90 days if they need to make a decision. They don't have to request it. They can just take it. They only have to basically let the chief judge know that they're doing it and why. That's it. But there's no way she's going to take more than 90 days for this. And I don't even think she should be taking 90 days personally. But that is, if they are supposed to try to rule within 90 days. If they, every month, the circuit court judges have to give a statement or a summary to the chief judge explaining how many outstanding decisions they have, how many days have they been outstanding. If it's over 90 days, why is it taking so long? Those are the types of things. Real-time stories, I do understand that. I do understand that. And I have to say, even though I feel like you come off way too argumentative, and maybe it's just because of the way it comes off in text or in chat, but I do think you're very thought-provoking. So I will say that. I mean, I do think that you bring up a lot of thought-provoking things, or points. It's just that sometimes it seems like you always come off as argumentative. I don't know why. Maybe it's, like I said, maybe it's just because of the way it comes off in the chat. But I do think that you have a lot of great points to discuss. No, there is a time limit, Maria. That's what we're saying. There's 90 days, but she can take an additional 90 if she wants to, but she can't ignore it. No, like I said, she has to explain herself to her boss, like the chief judge. I mean, it's not her boss, but you know what I mean. She does report to somebody, and the chief judge, her job is to make sure that all of the judges in her district are doing their jobs, that they're at least making these decisions clear, getting their dockets cleared out, and that they're not dragging their feet. That's why that's there. They have that.
So the information that I have on workwithkz.com that I got from Tracy says that the court should rule within 60 days, which would be May 10th, and has a max of 90 days, which would be June 9th. I think they wanted like a date.
Well, it's hard to get a date because the rule, and again, these are the rules for the judges, not the attorneys. Exactly. And it says, I thought it was 90 days from the time that the matter is, and here's the key word, submitted. That word submitted can have different meanings. Typically, it means when all briefs have been filed. Yet in this situation, we have 2 briefs that have been filed that haven't even been allowed for. The state filed a response that they didn't get permission to file. You saw how Zellner filed motion for leave to file a reply. So people who want an exact date, you're not going to get it. Just calendar it out 90 days from the date Zellner filed a reply, and then start looking. And then keep in mind, she can send a letter to the chief judge, or is it the presiding judge, Tracy? It's one or the other.
It's the chief judge. There's a chief and a presiding in the Court of Appeals, but in the district courts, there's a chief judge in each district. And I'm going to just address this because I just said Truth Monster said, so the chief judge is grossly incompetent as well. I don't even know how you got that statement. I just said that the trial court judge has to report to a chief judge, and that's why she can't drag her feet. So I don't know where you got the fact that the chief judge is grossly incompetent. I don't know where that came from. So maybe you can explain what you mean. But no, I'm just saying that she can't drag her feet and take it, and ignore it, because she has somebody to answer to as well. That's going to say, why are you not handling this case? Why are you not rendering a decision? It's been this many days. You need to get on that. So there is somebody that keeps judges from doing something like that. That's all I was saying about the chief judge. So
well, and the other thing is too, and I've heard, I think I've heard you talk about it, Tracy, and I think I've heard Travis talk about it, is that this is not the only case on Judge Suckowitz's docket. Like, this is not the only case that she's looking at right now. She's got a lot of other stuff she's looking at too. So a lot of people are making it seem like she's sitting there with only this case in front of her going,
right.
Just
to add what Travis said. So we don't know where the 90 days would start. We don't know if the 90 days starts from when Kathleen submitted the original supplement, because it all depends on what they consider, like he was just saying, considers, completely submitted or whatever. And since the state submitted a response without the judge asking for it, we don't know if the judge would have asked for it. So if the judge was intending to ask for it, then that changes the date versus whether she wasn't intending. If she didn't want a response, the 90 days will start from Kathleen submitted her original supplement. If she was going to ask them for one and they just beat her to it, well, then it would start probably from the time that Kathleen filed her reply. The 90 days would start, which just happened. So not just happened, but happened like what was that? Couple weeks ago.
Maria wants to know, what are the repercussions if she doesn't? Are there any?
It doesn't happen. Like I said, judges rule. I mean, they do. I mean, they'd be disciplined. She'd get a disciplinary, but that doesn't happen. I mean, they have laws they have to follow, so they do.
She was according to Zellner. I never calculated it myself. According to Zellner, she was 2 days late in filing her order on the issue of the, back with the computer disk and all of that. The court gave Zellner 30 days to file her supplemental motion back on the computer disk and that stuff, and then gave her a date by which to rule that was calculated from that date. And according to Zellner, she was a day or two late. And there isn't usually really any repercussion against the judge on it being late a day or two. And as Tracy said, she can get an additional 90 days by simply sending in a letter saying why. It's not a request. It's just a notification. So technically, she's got 180. Now, the big question I have is, she have 180 to decide whether, right now, both sides are, what's at issue is, Zellner says we need a evidentiary hearing to figure this stuff out on the bones. State has explained why they don't need an evidentiary hearing. In my view, their response only made it more clear why you need an evidentiary hearing, but we'll put that aside for a second. Then she's filed a motion to leave to file a reply, which points out why an evidentiary hearing is needed. So the big question now is, does she have 180 days to just decide whether an evidentiary hearing is needed? Or does she have 180 days, 90 plus 90, to figure out she wants an evidentiary hearing and to conduct that evidentiary hearing and issue a decision, findings of fact and conclusions of law on the evidentiary hearing? Or do each of those three segments get 180 days?
I understand what you're saying, but it's not, I mean, that makes it sound like it's going to drag out too long. It's not, first of all, it's not going to take 180 days. She's not going to ask for an additional 90. And I'm sure she'd be taken to task for needing additional 90. She went over the 90 days on the original petition because that was a huge petition that had hundreds of claims in it. And she only went a little over the 90 days. So there's no way she's taking 90 days on one claim. So I'm not going to, I'm saying technically she could ask for 90, but I don't even want to put the 180 days out there because people start freaking out about it. But yeah, she's not going to take that long. She shouldn't wait that long to file for a hearing. All the 90 days is that she has to rule on the motion in front of her. The motion is, what exactly is she saying in the motion? Is she asking for granting a hearing or asking just for the new trial flat out? I have to look at it.
I think she asked for a trial, or sorry, a hearing or a trial, or the conviction to be overturned, or any other relief as you see fit. Okay. Am I wrong, Travis?
No, that's right. But the body, so that in the boilerplate conclusion, she asked for all proper relief. But in the body of it, it's primarily asking for the reasons why an evidentiary hearing is needed. That's the thrust.
Right. I would say that because there's no way that she could have to grant a hearing and hold a hearing and give a decision in 90 days. So she would have 90 days to rent a decision on whether to grant a hearing or not, I believe. But I think she should do it sooner than that. But I think technically she would have longer. Or I should say that she should probably have to grant a hearing, hold the hearing, and make a decision maybe within the 180 then. I'm not really sure. I mean, it gets too confusing, but basically if if the judge decided that she did want this response and this reply, the clock wouldn't start till that reply was filed a couple weeks ago. So we could still have a month to wait at least, you know, but.
It was 17 days ago. I checked.
Okay.
Just so you know. You were asking and I checked.
Right. Thank you. No, it was 17 days. So, I mean, we're thinking about when she originally filed the supplement.
Mm-hmm.
If the judge is going by that date, well, obviously the clock is, you know, a little bit further along, but if it's just based on the reply, then we still might have a while to wait. So even though I do not see her waiting 60 days, even 60 days to grant a hearing if she's planning on doing that. Judges put that on their dockets. Sorry.
I'm sorry. No. I just, before the subject gets moved to something else, Fen asked something relevant to this. She said, is there any chance the judge could ignore both the state and Kathleen's unasked for filings and ask the state for a response at this point, thereby allowing the state to undo their F-ups in that filing?
No, they submitted a response. That's the response they're submitting. She's not going to say redo. You know, well, she could actually. The only thing she could do is she could say, you know, like a judge can say, okay, I want you to file a supplement answering this specific question. She could do that instead of just having a hearing. She might want specific things answered in an amended response, but I think she would just grant a hearing at that point. I mean, so it's possible, but no, they wouldn't be able to retract what they've already said, though.
That's what I was going to say, right?
No.
Okay.
No.
Truth Monster, and I know that you have talked at length about this, but I don't want to ignore the comment. Truth Monster was saying, if Willis and Fox and Suckowitz report to someone and still haven't been removed, that would make the chief judge grossly incompetent.
No, because it's not up to the chief judge to remove a judge. That they're elected officials. They would have to be impeached. That is not up to a chief judge. That would take like the Supreme Court to do that. Not a judge. I mean, they're elected positions. You can't remove them without impeachment proceedings. And come on, that's not going to happen, you know. But that would be up to the Supreme Court to hold that type of proceeding, not a chief judge. Chief judge just make sure that they're staying on task, they're getting their dockets cleared. That's what the chief judge does.
Senator Barrs always says, silly question, but can it go beyond 180 days?
No. I mean, not without a disciplinary type, some type of, it would be ordered. The Court of Appeals would then have to order them, give me a response within 7 days. You know, that's what they would do, because that is grossly over the time necessary to decide this type of motion. So the Court of Appeals would then file an order demanding that the judge act on it. But again, I don't see it ever coming to that.
If that's the case, then they do not report to anyone and are unaccountable.
They report where their standings are in a case. Like I said, the chief judge is an administrative position. They are there to make sure to tell these judges, hey, you're taking too long, you're dragging your feet on this, get a decision on this. That's what they're doing. Aren't in charge of them, but they are administrating just like you would have a manager in a business office. Just making sure that, you know, hey, I need you to get me this by this date. That's the kind of thing it is, but they're not their boss, but they are there to help them, you know, keep the judges like doing what they're supposed to be doing and getting their schedules cleared. The judge
let's go back a second. So the rule that we're talking about is a rule for judges that they have to follow. You know, no more than 90 days unless they enter a notice that they need additional time and they file that. So all of these rules were promulgated and put into effect by the Wisconsin Supreme Court with the ratification of the legislature. So there is an overarching system to track circuit court, trial court level judges. So there's a framework. So I think that's why Tracy and I have some confusion with the questions. There's a framework here to prevent stuff from falling through the cracks or from ending up being stuffed in the bottom drawer of a judge's desk. There's a framework in place. There are safety nets. We try and give you accurate information. The safety net is 90 days from the date that it's submitted, but you can request judge can notify the chief judge that they want another 90. That's the answer. You know, it's the paranoid stuff and spaceships from outer space, grabbing the paper, or dogs eating it. You know, it's, look, it's 90 days from the date Zellner filed her motion for leave to reply, and then possibly another 90 after that. So all we could tell you is check the docket every day, like you all do anyway.
Truth Monster, I'm going to say yes, because it's an elected position. Same thing as anybody else, any other elected position out there. If you don't like the way they're doing their job, you don't reelect them. That's how they're held accountable. You know, that's just the truth. I mean, you're talking about any elected position. Same thing with a sheriff. Who's going to hold a sheriff to account when they're the boss? You know, nobody except for the people when they have elections. That's it. That's how it works. You know, and that's why I don't think that's why it sucks that politics and justice have anything to do with each other, because they shouldn't. It shouldn't have anything to do with that. And one thing that is true, and Real Crime Stories did bring this up, judges don't want to keep things on their docket. You think that judge wants this case in her life any longer than anybody else? No, judges want to keep their dockets clear, because the longer they drag their feet on one thing, they're going to get behind on other cases, and they don't want to do that. They want to keep moving things along. So to say that, you know, a judge would purposely, no, they don't. That's not in their best interest either, to drag their feet on something. They want to get it out of their life just as much as everybody else does. So, okay, let's move on from that now. Something else?
Okay, that I already read. I didn't go. Oh, I already read those. Dark Side of the Moon said, "Have you met Kathleen? I'd love to see you to use to chat."
No, I haven't. I mean, I haven't actually met her. I mean, I was at the yard once when she was there, but I didn't actually meet her. And I've emailed, you know, her before, but no. But I can't say I've ever met her in person or anything. No, I mean, I saw her. She walked right by me, but no. No, other than that, no.
You were Kathleen adjacent.
Yes, that's I was Kathleen adjacent.
I don't have any other questions on standby. If I missed anybody, please ask your questions again. I didn't. Yes, Sue, you can message me after the mamathon. If I missed anybody's questions, please repost them. And I'm trying to keep up, but I'm so tired.
Since we have a little bit of a break, I'll say again, thank you to everybody. I know some donations came in while we were talking there. And so thank you again for the donations. Keep them coming. What are we at right now? I know that it was posted probably not long ago, but things scroll by so fast for me. What are we at total-wise?
Let me look. Thank you, Fen, for posting my links. Right now we got we are at $2,667.19.
So what we're shooting, we're going to say 2,800. We're trying to get to in the next
2,800.
Okay, and thank you.
I don't know how long
for matching or for adding that extra $100. That was amazing of you. Thank you so much.
Yes, you are awesome.
Real Crime Stories, like I said, I think that a lot of your points are very fair, and I don't take it as you're attacking. It's just, like I said, it seems like it's kind of, it just comes off bad, I think, sometimes. So no worries at all. Like I said, as long as you're respectful, I'm fine. It's just that, you know, when it comes off as being like argumentative, and I might not take that great, but I apologize if I, you know, overreacted to that as well.
$132.81 to get to 2,800. So $133. If we want to get to
lots of hearts for the mods, and for lots of rounds of applause. Thank you, Linda.
You guys are so awesome. Thank you so much for taking the time out of your weekend to be here and support this event, and to support the guys and share money with them to help them out so that they can buy things to make them feel more human. And they're going through some stuff. They don't, and they shouldn't be there. And I appreciate.
And one thing I'm going to say too about the difference between probably my videos and other people's videos is that, you know, if you go on Eric Hosey's videos or Allie's or whatever, they're. Did I cut you off, Julie? Because I don't know. I didn't hear anything. I didn't hear you talking anymore.
No, I'm sorry. I was just, Travis left. I don't know where he went.
No, where did he go? Okay. That is that I get a lot more questions. I get questions and give answers. Like they're part of a conversation usually. but I get a lot of questions and people want answers and they expect answers from me. And so it does sometimes get a little more frustrating when I feel like I'm giving the answers and people just aren't liking them. So, because they want to hear a different answer. So that is sometimes too why the tone of mine can be a little bit different sometimes and get a little more heated, is because, frankly, people don't like my answers. And half the time I don't like the answers I have to give because I know that they aren't, what people want to hear. Where everybody else that does these videos can say exactly what everybody wants to hear and everybody can be like, yay and happy. And we are all on the same page, where sometimes I have to be the bad guy or the Debbie Downer and just bring down the room and give the bad news that, so that's why sometimes the tone gets a little different too. It's not because I'm trying to argue with people or anything. It's just that it's a very different tone because, like I said, I'm sometimes the bearer of bad news.
But you know what? It's better to have an informed answer. It's better to have the right information. I would rather have the correct information and be able to manage my expectations correctly. There's so many people that just, they want to believe the good, exciting stuff, and it's just not true. And then they get so disappointed when it turns out not to be true. And
Right.
I think that the way that you answer questions and the way that you approach things helps everybody to reasonably manage their expectations in this whole situation. And personally, I really appreciate that.
And some people do. Some people tell me that they like that. It's just that sometimes, like I said, it's hard because when I give an answer, I certainly understand why people get emotional because they're like, what? That doesn't make any sense. That's so unfair. That's crazy. So I can certainly understand why people have an emotional response to an answer that seems crazy to them or seems so unfair. I'm just saying, don't shoot the messenger because I didn't make the law. I didn't write the law. I'm just telling you what it is. Real Crime Stories is saying, do you see any hope for Brendan at this point? Well, honestly, Brendan has a lot better chance on some of the claims than Steve does because Brendan has never filed a 97406. He is not procedurally barred from presenting any of that stuff, any of the stuff that Kathleen has presented that would also be relevant to Brendan's case. Brendan's lawyers can file, and he would not be procedurally barred from presenting them. So Brendan still has a very good case on some things, like the scientific evidence. They would have to have a hearing on those things for Brendan. Whereas Suckowitz was trying to say Steve was procedurally barred from it. So that actually is an upside to Brendan's situation. You just got to wait because they're waiting to see what happens with Steve's case on some of these things. That's the only thing. It's just kind of in a holding pattern, but he still has a very good chance.
So the fact that they're waiting to see what happens with Stephen they're not going to, the state isn't going to claim that Brendan's team is procedurally barred because they didn't file it right when they found out?
No, because it's under current litigation.
Oh, so that's
okay. If they want to file a claim and that claim is currently being litigated somewhere else, they then would have a sufficient reason as to why they didn't present it yet, because it would be logical to think that you're going to wait till there's a conclusion to that first before you present it.
Okay. That was something I didn't know. I didn't know that if it was under current litigation, they could wait. Thank you, Rachel, for your donation.
I should say that.
But just so there's no confusion, that they're stuck with that confession. That's fully litigated and it's never going to change. So these forensic things that Stephen has been able to develop through Zellner and the ineffective assistance of counsel may cross over. It's still trying to determine the issue with the bones that's most recent, how much of that may carry over. And so I think they're waiting and seeing how some of these things are going to come out. They can bring a motion on all of those things, but again, I hate to be the bearer of bad news. There's not going to be a second opportunity to argue what was, I thought, the strongest part of his case, that his confession was coerced. That's the law of that case. Unless something happened where the Supreme Court took another similar case and made the decision retroactive, his confession is always going to be deemed to be good and legal. So he's got to find another way to do it.
Hi, Falcon.
I want to go back. I know Maria was it Maria that just asked a question about transcripts?
Yes, I copied it down, but yes, you saw it.
I don't remember if you answered if Court of Appeals is nudging for an evidentiary hearing since they want transcripts this time. I don't know what you mean by they want transcripts. I mean, they put in the Court of Appeals order, if anybody needs to order transcripts, they had a certain amount of time to do it, but that's a standard order. That was on their last remand too. No, we absolutely did, Maria. You were fine. It scrolled past me again, so I wanted to catch it this time before you had to repeat it again.
Cinnabar Zoe says we should have a donation off again to get to 2,800.
That's what I said. I've kind of moved it up a couple times, or once at least already.
Hey, why not? Shoot for the moon, right?
Yeah, that's what I said. Let's get up to 2,800, and then I'll challenge everybody to get up to 3,000 before the end of the last hour. So,
there you go.
Or get up. Yeah. So why not make it fun?
We need $122.81 to get to 2,800. We are 66.9% of the way to our goal, you guys. I cannot even. You guys are so awesome. My heart is smiling so big. You guys are amazing.
The legal system is a clusterfuck. Yep. Most on point statement of the day.
Right?
It is. And no, it is not justice. That's why, I said that there's very little that is just about our justice system.
I agree with Eric Jose's comment.
It's an abomination that ridiculous confession stands. Absolutely. And even if Brendan does get his conviction overturned and they humorously want to try to retry him, that confession still stands.
Well, but they can argue it again, right?
No, it's been fully litigated. So no, that actual confession is in no matter what.
Rude.
Mm-hmm.
Ooh, there's GoFundMe donations. Hold on. Updating right now.
Ooh, we get so excited.
I know if anybody's actually watching me on the video when you guys are talking and I see a donation, my face gets all excited. They probably know before I even say anything.
There is only one segment where Julie was an official guest, and yet she's been on with me, like answering questions or keeping questions and moderating me with the video feed this entire time. So I can't tell you how much I thank you, Julie.
Oh, you're very welcome.
You're only supposed to have to give me like a couple hours as a guest. That's it. And you've just been my permanent guest full time.
That's perfect. I am happy to help in it any way I can. Okay, so we got a donation from Vibik. I don't know if I'm saying that right. And Anne Marie. So thank you very much.
Thank you, both of you. Yeah, Eric, it's June 15th is the rally, and Fen just posted the link to the Facebook group because she's on top of it, and she's posted again.
15. Whoops.
All right, we actually have a lull here, so everybody got quiet all at the same time.
I'm trying to incite a donation off to hit.
We filled up 2 hours pretty quick, though.
Well, that's good. Travis, are you still here? You left for a second, and I was like, where'd he go?
No, I'm here. What happened is I got a telephone call in, and I'm on my phone, and I answered it briefly to let them know I would call them back, but smartphones being smart, automatically disconnected me from the online call through Google Hangouts. Anyway, that's what that was. But I saw you guys already posted the links. Not to go back into the time frame question, whatnot, how long just to decide. The two sources for that are you go to Julie's Working with KZ website, and she'll have the best information that she can put on what the next step is. And then the other go-to place is obviously Tracy's Basically a Lawyer Facebook page. And if you're not part of that, be sure and join. It may be a few days before we're able to get, it's a closed group, tries to keep things focused on the law and strictly the law related to the cases. But do we know if people can be added until that 28 days expires, Tracy?
Somebody said that if we post a direct link, then they can get to it, but I don't know. I didn't test it myself.
Okay.
Can somebody click that link and let us know?
If the group comes up or not.
somebody who's not already in the group,
Yeah.
can you click the link and tell us if it takes you to it, please?
Probably everybody here is probably already in it.
But whether that's
autocorrect is killing you this weekend. That was like the second autocorrect.
but then you can post questions in there and ask these types of questions, and then if they've been answered, we'll refer you to where they've been answered. If there's updates and whatnot, she'll get you updated with the latest that's known. And so if you're interested in the legal aspects of the case, Tracy's Facebook page is an awesome source. And then Julie condenses everything down in a color-coded pattern that has been helpful to a lot of people that aren't used to tracking motions and briefs and appeals and so on and so forth. She's laid it all out visually where it's very, very understandable. And she also condenses down what each thing is. So, whatever depth level you want to get to between those two, super in depth with Tracy and legal analysis. You want to just kind of know where do things sit and what's coming up next real quickly. You can go to Julie's webpage, and between those two, you're going to know exactly what you need to know from the legal side of things.
Tracy or Travis, do you know why Kathleen removed her donation link?
Nope. No idea.
KW.
Okay, go ahead. That's what I was just going to go to. Go ahead.
Isn't the whole point of the remand is to get answers to the bone issues? Doesn't this mean that Judge Suckowitz would have to do something to get those answers?
Well, yes, other than if she decides that it's procedurally barred, then that would be the something she would do. She'd say, you're procedurally barred, so I'm denying this.
Right.
So, that is the only reason why she would be able to get away without even considering it. And considering her track record, I can say that I think Kathleen's expecting her to say that, because why else was she saying that, the expected adverse ruling, let's just get on with it. Because that's really the only way you can deny it. Unless there is not, I don't believe that there is enough facts known for her to outright deny it on the merits. I don't think she can deny it on the merits. I think she can deny it as procedural bar if she wants to, but I don't think she can deny it on the merits without a hearing. That would be just wrong.
Oh, Fenn says, I'm sorry. I was totally interrupting you. I'm sorry.
No, I keep doing that too. It's hard.
Fenn says the donation link is still there, and she linked to the page. And thank you, Travis, for saying good things about my website.
Yeah, the work of the website is great. Julie is so on top of everything. I'm just going to call her Wonder Woman. Be happy that the group is coming up is not available right now, and that is because it's secret. I'll be able to change that in about a week. So keep the link handy if you want to join, and just remember.
Yes, keep the link. If any of you follow me anywhere on Twitter or on Facebook, or if you follow Tracy on Twitter, or Wonder Pom Pom, I don't know about that.
I love that.
You can always, or if you're in the Coze Wrecking Crew Discord, you can get in touch with any of us and we can give you the link to it. But bookmarking the link is also a very good idea. Probably the best idea, because then you'll just have a direct link to it and you don't have to send us a message. But
so I apologize for that. It's definitely inconvenient, but that's just, can't do anything about it right now. I've tried, can't do anything. So
his innocence matters, and he would never be reconvicted with zero physical evidence against him and only a false confession. No, Alford. Oh, sorry. She was replying to.
Okay, I'm going to address that for a second, because people say, no way should he take an Alford plea because, he's innocent. But you have to look at it from Brendan's perspective. I don't think Brendan's first priority is getting rich on a wrongful conviction thing, especially if there's no guarantee he's going to get out. Brendan wants to get out of prison. So it's not really for us to be able to say how we would react in that situation. Brendan might very well be interested in taking an Alford plea just to get out of prison. when the alternative is 30 more years, over 30 more years. You can't fault him for at least thinking that that is a possibility, and the state will understand that as well. And so, yes, if Brendan's conviction is overturned, they may try to offer an Alford plea. And the only reason why I think that Brendan could possibly consider it is because of the confession, because that's still in there. Because you can't guarantee that he wouldn't get convicted again. And so I'm just saying, like, you can't just say right away that no, he'd never take a plea because he's innocent. After spending 13 years in jail as being innocent, maybe he decides that, you know what, I don't care, I just want to come home. And I don't care about the money, I just want to come home. And at Brendan's age, I can understand that. Steve's a little bit different. Steve has been very adamant. He is not walking out of prison any other way than as a free man, an innocent man. That's it. He will take no deals, no anything, nothing. He's all in. Yeah, so I said it's something that he has to consider, because he is a young man still, and he has a lot of life left. And if it's a decision between spending it in 30 more years in prison or possibly getting out tomorrow, you can't just say, absolutely not, I'm not going to take it. You have to consider that for sure. Even though it'd be horrible. It would be horrible for him to have to, take a plea like that. But, it's something that would definitely be a consideration.
It's not an unreasonable thing to consider, I don't think.
Right. I don't think it's fair. But again, if it gets him home, you do what you got to do. And there's nothing saying he still can't try to, prove his innocence when he's out. But it's just that you won't have anybody doing it for you. You're not going to get anybody to keep investigating, so that's the thing. It's like you can still always try to continue to prove your innocence, but once you're out, usually it's just like you've got what you wanted, you got your freedom, and that's all that matters.
So Victoria Fuller has a question. She says the jury asked to hear Bobby's testimony in Stephen's trial, and Judge Willis said what part, and they said all of it. Judge Willis told them to go from memory. Is this normal in court?
Yes, that is standard. That is absolutely standard in any trial. You are allowed. You are usually allowed to take minimal notes. The reason is because a jury is supposed to decide credibility of witnesses based on watching, hearing, paying attention. If you're one of those people that writes down every word you're hearing, then you're not paying attention to their body language. You're not paying attention to, inflection in their voice. You're not paying attention to those things. And the court wants people to pay attention to the person talking, not writing down a bunch of notes. And it is ridiculous to think that a lay person especially is going to remember everything that a person testified to in a 3-week trial. Imagine the jurors from the OJ trial, like trying to remember who testified to what 9 months ago. But sadly, that is the case, and they do not usually give entire transcripts. They will give little sections, but no, that is the norm. In my county, both my husband and my daughter were summoned for jury duty recently in the last 8 months, and in both of the trials they were involved with or going to be involved with, I should just say, let's just go this way. One of the judges for sure in Walworth County where I live allows questions to be asked of the witnesses in a courtroom, which is unusual. There are only a few judges that allowed that, but the judge in one of the judges in my county actually does allow jurors to ask questions of witnesses and things like that, which is pretty cool.
See, that bothers me because it's especially troublesome when you think, what if the attorneys are saying things that are not true and you can't go back and compare it to, like, I feel like it's unfair. Yeah, you're supposed to be paying attention and watching, but without the ability to go back and review everything, I don't think that is conducive to making an informed decision. And somebody like me, who I say all the time, I have the memory of a newborn goldfish. I'm not going to remember a lot of that stuff. I'm going to get an impression about somebody, but when you're in there deliberating and people are saying, well, this and this and this, I'm going to be like, well, yeah, but I didn't like it. You know what I mean? And
right.
there's
And
nothing
especially when you're talking about
fair.
When you have a case that's very heavy on expert witnesses. And like I said, you're a lay person. You have a high school education, and that's the most you have. And all of a sudden, you're going to get all this testimony from a DNA expert, a blood spatter expert, a crime scene expert, a forensic anthropologist, cell phone testimony. And you're supposed to remember all of that. Not only remember it, but analyze it to come up with some type of conclusion. That is a lot to put on anybody, especially when you heard about it 3 weeks ago. and you've heard so much since then. It is unreasonable, but unfortunately that is what the rule, and that is standard.
It sucks.
Mm-hmm.
Just saying.
Yeah.
Victoria, I gave you a link to our Discord. Just click it so you can go there.
And somebody else already said that too, that you can't.
Okay.
So just save the link for later if you want to join, and just join next week when I can open it again.
Yeah. Dassey would be fine with an Alford plea. Look at the West Memphis 3. They all took out an Alford plea, and they have no issues when it comes to many people seeing them as victims of the justice system. Yeah, well, that's them.
But the one thing with Brendan, though, Brendan would still have to register as a sex offender. That is a big thing. That is one thing that is sucks. It's not just being a convicted felon. Brendan would have to register as a sex offender the rest of his life.
Man, that sucks.
Mm-hmm.
Poor Brendan. Oh, my heart breaks for him. I watched part of the McStay murder trial, and jurors could ask questions of witnesses while they were on the stand before they were excused. Oh.
Yeah, in my county, they go through the judge. The questions go through the judge, but they do allow, because the judge, what happens is the jury will have a question of a witness. They'll submit their question to the judge. The judge will talk to lawyers because they want to make sure that nobody says anything that would be prejudicial or, anything. So they have to make sure that it's within the guidelines of what a question a lawyer would be able to ask, essentially. And then if they approve, then they ask the question, and then the witness can answer. So, there's still a series of checks and balances to make sure that nothing is said prejudicial is said or anything. But at least it can be asked. Can you imagine the Avery trial if you could have asked questions of the witnesses?
Oh my gosh, that would have been amazing. That is one very good reason not to take the plea. Horrendous, shocking, but I understand why in the legal sense.
Yeah. That would be a very hard decision to make. It might not be. He might be like, nope, I want to go home, period. But there would still be obviously a downside that he would have to consider. But, we don't know. We don't know what Brendan would want. And I can certainly understand if he just wanted to come home.
Jurdog, what do we know who the jury was on this case?
Yes, it's out there.
Stephen, what's the truth that the jury felt bullied by the system?
That no juror other than Rick Mahler, who's the excused juror, no juror has come forward and had any issue with the case and anything. We had the filmmakers say that somebody came forward and said things, but there's no actual official word from the jurors. I know there were jurors on Facebook that still absolutely think he's guilty. I did see their posts when Making Murder First was released, and they were so outraged by it.
Jody Arias was asked questions by the jury. We were offered to ask questions directly to written question to bailiff to judge, and both counsel brought up to agree, and then the question was asked.
Yeah, that's exactly how it is here too. Yeah, and I think that
would be great.
Yeah, it's not all judges allow it, but it's becoming more of a thing. And I think that's a sign of a judge with an open mind that wants to make sure that all the facts that need to be presented. So I think that's a good sign when judges do that.
That's more along the lines of seeking justice and less along the lines of seeking a conviction.
Right.
Were the bones brought up in Brendan's appeal?
Brendan's appeals so far have not consisted of anything other than ineffective assistance of counsel claims against Len Kaczynski and the confession. That's it. Any other claim is still fair game.
Has anyone come across the YouTuber who claims to have been a juror and has these videos showing us news coverage that Judge Willis was sending him during trial?
Well, the perfect person just showed up to answer that question. Jinx, you would know that probably better than anybody.
Jinxie, hi. Jinxie, can you answer that question?
About the Jennifer's question above you. And yes, there are a lot of county connections, at least. And that's the problem when you come from a smaller county. Everybody's related in some way. And that makes it very hard, again, to know what's suspicious and what's not.
Jinxie, the question is, has anyone come across the YouTuber who claims to have been a juror that has these videos showing us news coverage that Judge Willis was sending him during trial? Excuse me, sorry about that.
I've never even heard of that before. So
I haven't either. While Jinxie is answering, we got another donation. And we are now at $2,727.97. So let me see.
Yeah, Jennifer, that's Rick Mahler. That was the excused juror. Yeah, he's the one juror that has talked about the case.
$72.81, you guys.
That's what we need to get to 2,800.
That's what we need to get to 2,800. $72.81.
$72 in an hour and a half. $72. Well, I was trying to go in a half hour. $72. $72 in a half hour. We can do it.
Yep, we can do it. We got this. So Scotch Andy is saying that in the UK, it's 7 years registered as a sex offender, not life.
Yeah, here it's lifetime registration.
Yeah.
And thanks, JC. Once she explained the name, then I knew who she was talking about. But thank you for answering.
They all got a copy of the news as promised to them so they wouldn't be tempted to watch the news, is what Maria said.
Yeah. Jurdog, with Brendan, how did they rule on the interrogation when his mom comes in and he retracts? I mean, they did. That's what his entire post-conviction process has been about. Whether, whether he confessed falsely. And the court decided that it wasn't an involuntary confession. So that's that. And people confess and recant all the time. People who are guilty confess and recant all the time once they get in a lawyer. So it's not just something that people who are innocent do. I mean, it's pretty common for anybody that confesses to recant once they get an attorney. So that's not an automatic belief that the person's innocent. That's just something what everybody confesses does usually, unless they're planning on pleading guilty. That wasn't what happened. That's what they thought at first, that Rick's daughter was in a car crash. Turns out she just had car trouble. But he didn't know that, and he left, and it's just unfortunate, but there was no car crash. It's just what he for some reason thought that it was a more serious situation than it was.
Becky said, Jurdog, they didn't show that. They didn't show it during the trial, but that's like Tracy was just saying, that was the whole point of the appeal. It was brought up there. The part where Barb came in and he recanted. They didn't show it during the trial.
Right.
But they talked about it a lot during the...
Yeah, Julie's just, I mean, I think that's what we all think, Julie. Like, how could they not have reasonable doubt? I think every piece of evidence they presented had reasonable doubt, let alone just one reasonable doubt about anything. That's what we all say. We can't understand it.
Good night, Jane.
Rick has said himself that it was not an accident, that it was just a car trouble that she had. He has said that himself. That he thought it was more serious, but he later found out that it was not. That's what he said. But again, Rick did not say that. He did not say that he was told it was serious by anybody. He said on his own, he testified to this during the post-conviction hearing. He said that because they asked him very clearly, what gave you the impression it was serious? And he just said it was a tone in his wife's voice or something. Nobody actually gave him anything to let him think that it was serious. He just, for some reason, thought that it was. His wife sounded upset, and he thought that it was more serious than it was. So yeah, that's just, I'm going by what, I mean, I've talked to Rick too, but I'm saying about what the testimony is, and that's what you have to go by, is what he said. And there's a lot that's still improper about that, but ultimately, Rick left of his own accord. I mean, I think he just didn't want to be there anymore.
We just got, sorry, go ahead.
Oh no, okay. Almost to our segment goal, Fence saying.
We just got 2 more donations.
Is the law any responsible that you must find not guilty? Oh, yeah. The law is if you find any reasonable doubt, you have to find not guilty. Yeah.
$53.81 we need.
Yay, $53. Yeah, that's the thing, Roll, is that there have been different stories, and God, I'm around Rick enough. Maybe next time I see Rick, maybe I will ask him to clarify, because I know there have been different stories, and so I'll ask him directly next time I see him.
Thank you, Andy and Dawn, for your donations.
Thank you both.
Yay.
Yes, James. And that's why I said I think everything has reasonable doubt, attached to it. So I don't know how they couldn't find any. I think everything has reasonable doubt.
Mm-hmm.
And that's what Mike was talking about too, though, about how this jury instruction is so unfair to a defendant, because the jury instruction says you are not to search for doubt. You are supposed to search for truth. And when you say that, that's suggesting that you should draw a conclusion about guilt or innocence before you even evaluate the case. Well, how can you determine they're innocent or unless you, or like they said, you should search for the truth. Well, how can you search for the truth when you're not even evaluating anything? And how can you're not supposed to search for doubt? I mean, that doesn't even make any sense. You should be questioning things. That's the whole point of deliberating. And so that's why they don't like that instruction. And that's, he explained it as putting the cart before the horse. Just like how Kratz said, reasonable doubt is for innocent people. Well, you can't do that. That's drawing a conclusion about their guilt or innocence before you're even deliberating. And that is against what you're supposed to be doing. That person is supposed to be innocent until proven guilty, until you just deliberate that case. And so that's why, to say that is terrible. And that's why that rule, everybody, so many people want to get rid of that rule because it is very misleading. There's nothing wrong with searching for doubt. You should be questioning things and say, is there any doubt here? If not, then I'm going to vote that they're guilty because I looked for doubt, couldn't find any. That's,
You didn't need to search for doubt. There was so much of it that it hit you in the face with a brick.
Yeah, that's the other obvious statement. Yeah, is that you didn't really need to search real hard to know that there was problems here, and that's why it's so hard for us to understand, because to us it's just like neon sign that with everything that there's something wrong.
Eric has a question. Could Brendan, if all else fails, file a motion for reconsideration of sentence?
Well, that's what a 9746 is. It's a request for sentence modification. So so that's actually what that is.
How about Brendan bringing up the issue there's no evidence to corroborate?
That was brought up extensively by his attorneys in his post-conviction proceedings. That was brought up over and over again. Some judges agreed, some judges didn't.
Yes, be happy. You are supposed to be presumed innocent until found guilty.
Yes.
Supposed to be.
I am not a fan of the whole let's take a preliminary vote thing. I think that's incredibly unfair. If I was on a jury and someone said, let's take a preliminary vote, I would say, why? Right now, he's innocent. Until we sit down and discuss this case, this man is innocent. There should be no question about it. I don't care, if you are outraged the entire trial, that man is innocent until you, as a group, deliberate that case. That is how it's supposed to work. So I hate when I always hear about this preliminary vote stuff, because I think right there, you're not doing your job.
Mm-hmm.
Personally, that's how I feel. I mean,
welcome back, Travis.
Travis is just in and out. And you were having technical problems yesterday, too.
He's outside.
It must be nice living where it's warm. It snowed here, so.
Is there snow? There's no snow here.
I think it might have melted already, but my car was covered last night.
Really?
Mm-hmm.
Huh. Yeah, I haven't. Travis is noisy.
I'll mute that. Hang on.
No, it's fine. Do you have something to talk about?
No, I just popped back in. I was out for 10 minutes. What are y'all in the middle of talking about?
I think we were talking about reasonable doubt.
Yeah,
reasonable doubt.
Juries in general and some of the jury stuff. And we're kind of just taking questions as they come right now.
It's 87 degrees.
Whatever, Maria. Way to rub it in.
And I was talking to my son and I was like, oh, it's cold and rainy. And he was like, must be nice. It was 90 the other day. I was like, oh my gosh.
Well, I hate being on lives with both Travis and Eric Jose, because one's in California, one's in Texas. And I am like the pale Wisconsinite in the middle of blizzards every day with 12 inches of snow. I'm like, you can tell who the pale one is in this group. I look like a ghost compared to them.
Well, I've been in Canada since July, so.
Rule, and that is the point. That is the problem. If they could have proved that he never deliberated, that would have been juror misconduct. But since Rick Mahler left, he could never prove that he never deliberated. Rick said that he didn't deliberate in the short time he was there. But unfortunately, since he wasn't there during the duration, then there's nothing they can do about it. But that is absolutely wrong. That is juror misconduct, but there's no way to prove that he maintained that stance the entire time.
I heard the jurors were visited during dinner by the sheriffs.
That was Brendan's jury that happened, yes. And again, it was reported and they determined there was no misconduct. I mean, as I said, that's why when Mike was saying that, he's like, that they find a way to say that it's okay. And that's why it's so hard. As a defense attorney, I can't imagine how frustrating that is.
Let's see where we are. We need.
So did Mike talk about the case that's on appeal right now about the jury instruction about looking for reasonable doubt? Did y'all get a chance to talk about that?
Yeah, we talked about that when you were gone. You missed it. Sorry. It just happened to come up again. So yeah, we talked about that.
Okay.
And why that's so unfair to a defendant that you add a instruction like that. Wait, hold on. What do you mean? Why is what not tampering? Oh, the pizza? Because they all testified that they had very little contact with the jury, that nothing about the case was discussed, and that's all it took, is for them all to attest to the fact that there was no misconduct. And so therefore there's no misconduct. You can't prove otherwise. That's the problem. Nobody can prove that they did anything wrong. So.
Sorry, I was looking away for a second. That's why deliberation rooms should be recorded.
Yeah,
that's what Eric says.
I also believe that there should be a jury education specialist, that it should actually make sure jury truly understands what they do. You take a bunch of people that know nothing about the law, and some do obviously, but in general, like I live in farm territory here. I take a bunch of farmers, and put them in a jury on a murder trial. They don't know the first thing about the law, and yet they're expected to understand all this stuff with these experts and this, and there's nobody other than the judge saying, this is your job. If you find them guilty beyond a reasonable doubt, whatever, then, that is it. That is like, they don't get any training, anything on how to be a jury, what you actually have to do, what your job is. And most of the time people just want to get home in time to have dinner, so it's very unfortunate that, that I don't even like the jury system. And I can't say that I wish it was a judge, a bench decision either, because we know that judges are biased. So I don't know about a better solution, but I personally am not a big fan of the jury version of it, because I think that juries are in general too uneducated to be able to actually understand what they're hearing most of the time. And that's nobody's fault. I mean, that's just like how many people are educated in the law,
Well, everybody who listens to you and Travis.
Yeah, of course. And if a person has gone to college and everything, then they probably will be able to follow, even if they're not interested in law in general. But when you get somebody with like I said, with just a high school education, or even a high school dropout, whatever, or a GED, it's going to be very hard to understand all these complicated concepts that are coming from a lawyer, from, like I said, expert testimony. That's a lot. And when you're talking about possibly depriving somebody of their freedom for the rest of their life, that's a lot to put on somebody who really does not have the qualifications to make a just decision on that. Again, I don't know a solution. There's no maximum for the commissary. The only limit is that you can only deposit $300 a day per person. So I would have to deposit it over various deposits, but there is no limit to how much they can actually have in their canteen.
Truth Monster asked if you could expand on the notion that there's a mistrial if a juror doesn't deliberate, with examples, please.
Well, I said one of the things that one of the responsibilities of a juror is to fully deliberate the evidence, to keep an open mind, to examine the evidence and come to basically an educated decision based on their conclusions after looking at all this evidence. When you have a juror that says he's fucking guilty and is not going to sit down and even talk about the case, and sits there like this and refuses to even look at the evidence, that is juror misconduct. You're depriving the person of their right, the defendant of their right to have a fair jury. And if Rick Mahler had been there the entire time and been able to say that Carl Wardman never looked at the evidence, never discussed it, he decided he was guilty and he didn't say another word until the end, then they could have proved misconduct. Well, even then it would have been maybe hard because it's like I said, it's a he said, but that would be considered juror misconduct because you're not doing what your job is supposed to do. And you are essentially, you're predetermining the person's guilty and you're not supposed to do that.
Wishful thinking, but if one of them should walk out tomorrow, do they get the balance of their canteen back? I believe so.
Yes, and Brendan actually would have a release fund as well, that a portion of his canteen for a while was put away to a release fund. So I believe it's like $5,000 or something like that. Steve obviously doesn't have one. But that was he hit that maximum after the first making murder.
Do you not think the jury in both cases might have felt intimidated by all the media and become one-sided?
Read that again, sorry.
Do you not think the jury in both cases might have felt intimidated by all the media and become one-sided?
Well, yeah, I think that's obviously what happened in some cases. Yeah, I mean, and they all but one juror that was in the entire pool said that they hadn't heard, or hadn't heard anything about the case. But again, all the juror has to say is, nope, it's not going to influence me, and you can be on the jury. That's all they have to do. The judge will ask, can you remain impartial? Yes. Okay, yes. You're fine. There's no reason you can strike this person, That's how easy it is to stay on a jury. So if you have somebody who has very strong feelings about a case and they're like, and they just happen to get picked for the jury, their intention the entire time could be to vote guilty. I'm going to make sure I get on that jury, make sure that guy doesn't get away with this. It's happened, I mean, that's why.
That's always the concern as a defense attorney with the more serious allegations, is that trying to explain to potential jurors that the presumption of innocence and proof beyond a reasonable doubt apply in the case, and that you're concerned that because of the serious nature of the allegations, that they might not apply the presumption of innocence, or they may let the state get by with a lower standard of proof. And you question them on it specifically. Like Tracy says, if they say, oh no, I'm going to hold the state to their burden of proof, I'm going to make them prove it to me, that's all they need to say. But jurors as a whole, that's one of the big fears. It's been studied that they do feel pressure, that they, especially in a small community, that they're going to go out, whatever decision they make, they're not only going to have to live with it in terms of that specific defendant and applying the principles, but they're going to have to go out in the community and run into the chief of police and the mayor and family members of an alleged victim, and have to look them in the eye in church and the grocery store and the beauty shop. And no, it's a significant problem in small towns. It's a pretty big deal.
Tracy, if you're not a fan of the jury system, what type of system would you wish to see?
Well, that's what I said. I don't have a solution. And I guess I shouldn't say I'm not a fan of the jury system. I'm not a fan of the jury system in its current state. If we would have like a way to better educate jurors, then maybe I would be fine with it. It's just the way that it is now, I don't think is working. And thank you, Vanessa. Thanks for bearing with me, and have a good night.
Okay, so I'm going to say this, and once I say it, before I say it, I wanted to just remind everybody that we are only $54 away from the goal of $2,800. So, Julie says, Tracy, I've so enjoyed your mamathon sessions. You know your shit, girl, and you don't take any. Okay, so Lori Smith says, I was late to the party. Did you talk about our rights under the Fifth Amendment?
I talked about that with Mike when he was on Saturday. I'm like, what day is it? When he was on Saturday morning. The most important things to know are that just because you're under arrest does not mean they have to Mirandize you. People think because of TV that you see it all the time as they're slapping the handcuffs on, you have the right to remain silent, blah, blah, blah. That actually they do not have to Mirandize you. Because they don't want to, because they want to try to get you to talk. Now, if they have you in custody and I put you in an interrogation room and question you, then they have to Mirandize you. But until they take that until they fulfill both things, you don't they don't have to Mirandize you. Now, and then the other big thing was that even if they Mirandize you, if you have not been placed under arrest, you are welcome to leave. You have the right to leave. Now, they may try to arrest you once you leave and say you're not going anywhere, but you still have the right to leave. And in certain circumstances, if they haven't started questioning you yet, if they give you your Miranda rights and you get up and walk out, chances are they don't have enough to arrest you yet. So don't give them anything. Those are the two biggest things. Are just, and don't believe them when they say that it will go better for you if you help us. This is your last chance to tell your side of it. Don't believe any of that. Just get a lawyer. It will not be held against you. And also, they can lie. So if they tell you your DNA was somewhere and you absolutely know for a fact it couldn't be, then you don't make up a reason that it was there just to try to, think of something. Don't always believe that they have what they say they have. You get a lawyer and let your lawyer find out what they really have on you.
Travis always said to us, and I repeat this all the time, anytime law enforcement ever wants to talk to you, ever, for anything, the only response you should ever give them is, I will be happy to talk to you as soon as my attorney is here. That's it. Say nothing else. I was watching it was like a I guess a short documentary type of thing. It was like an episode of a show with Kathleen about this case, and the little girl had disappeared, and they found the little girl, and she had been killed, and they were searching for the killer for like 5 months, and then they eventually arrested the father, and they got him to confess to it. They had him in this room questioning him for like hours and hours and hours and hours, and they told him that they had video footage of his car at the gas station on the way in between his house and the location where they found the little girl. And they had him so convinced that they had this video footage, and he's like, but I didn't go there. And they were completely full of crap. And when the video footage was actually reviewed, it wasn't even the same kind of car as his. But Kathleen went in and of course got him off. But when I was watching that, that's what you were just saying made me think of that, because they are allowed to lie to you. They can tell you that they have all this stuff on you, and if you know they don't, you stand your ground. Just shut up and wait for your lawyer to get there, and don't say anything.
And I have to say that I am so tired that I didn't even realize that I didn't change the topic of that. I remember when I'm done, I'm going to have to change the title. I didn't even realize I didn't change it, because that was originally what I was going to start discussing today. And then I covered it with Mike yesterday. So I apologize. I didn't even realize that that's what the title. All of you that showed up to talk about your Fifth Amendment rights, and I'm like, whatever, I'm not talking about that. So we cover it a little bit. I didn't even realize, even I'm staring at it, I still don't realize it. So, but yeah, that's the thing. And yes, real crime story. You're right. That it is very sad when it comes to juveniles, because when an adult doesn't understand their rights, how can a juvenile expect to understand them? And that's why a lot of states have pushed to have a juvenile Miranda warning that is actually much more easy to understand. They are required to have to put it in, like have it explained back to them in a way that, that the person understands. Unfortunately, a lot of cases, kids still will talk, but at least, they have a better chance of not accidentally incriminating themselves.
Well, and I still don't think that any child should be allowed to be interviewed without an attorney present. I don't think that it should be allowed ever. I don't think somebody under 18 should be able to waive their Fifth Amendment right, their Miranda rights, or their right to not speak. I don't think that anybody under 18 should be allowed to do that. I don't think it's fair.
You can't sign an enforceable contract under the age of 18, but you can sign away your human rights, you know.
Exactly.
It's ridiculous, you know.
You can't buy a pack of cigarettes, but you can incriminate yourself and go to prison for the rest of your life.
Yeah.
What?
That's it.
I'm not condoning smoking, everybody. Smoking is bad. Don't do it.
We were all walking zombies, yes. And I actually got more sleep last night than I have in like 3 days. Still is only 4 hours though.
Yeah, I only got 3. I wanted to get up to catch this.
Last night, I have to tell you, after we're done, Julie and I talked for about another 15 minutes, and we're both like, we're going to bed. Okay, I'll see you in the morning. We're going to bed. And like within minutes, we were both over at Remand.
It's hard to walk away from this.
Totally our own fault. Yes, it is our own fault.
This is such a great event. And you guys, everybody, please thank Tracy. This whole thing was her idea. And she put all of this together, and it is absolutely an amazing, amazing idea. And the event has been great. And you guys as viewers and subscribers have been awesome. And my heart is so full this weekend. But be sure that all of you thank Tracy for coming up with this idea and putting this together. This was amazing.
And I'll say you're welcome in advance of the thank yous. Travis, why don't you conquer? Because you probably hear the Miranda warning a lot more than I do. So why don't you answer that one?
Yes.
So what's the specific question about Miranda?
Can you explain the Miranda and how they could ask a 16-year-old to waive this, especially one with a low IQ?
And where did the name Miranda come from? While you're at it.
Unless you don't want to, I can answer it.
No, it's so Miranda is judge-created law, interpreting the Constitution, and 1963-64 under the federal system, you could not, FBI agents could not question suspects if they had demanded a lawyer. And then they adopted procedures where they would advise federal suspects if they wanted to have a lawyer. So in Arizona, this gentleman, Miranda, was a suspect in a brutal rape of a woman. And he was picked up kind of as one of the usual suspects. And he was uneducated, low income. Although he'd been in the criminal system, he was not adept at criminal procedure. He simply just didn't know that he had the right to ask for an attorney. And so they questioned him over several hours, and he finally confessed. And then it went up to eventually the U.S. Supreme Court, and the Supreme Court did what they were doing at that point in time. They incorporated the Fifth Amendment right to remain silent and to have counsel. They incorporated that and applied it to the states where it was required that the states also indicate that a lawyer would be available, that you don't have to answer any questions. And so they reversed it and sent it back down to Arizona. He was retried without the conviction, without the confession. He was convicted again. So that was in the early part of the 1960s, the Warren Court, Earl Warren, led a Supreme Court that had many rulings regarding criminal justice reform. So right to counsel in a felony case, states had to provide under Gideon and Miranda, and on and on and on. criminal justice reform decisions, pulling in the states. And ever since Miranda was passed, from the time of that the court started to go from, and I hate to use these, the L and C label, but liberal, conservative, there was a swing after Nixon was elected and more conservative justices. And there's been a tendency to retract Miranda. So we have all of these exceptions to Miranda. Now, they had an opportunity under the Rehnquist court to totally repeal Miranda, but they said it's part of American jurisprudence, and under stare decisis, we're not going to get rid of that decision, but it's eroded a great deal. So here's the problem. Everybody knows what Miranda says because you've heard it a million times on police shows and movies and so on and so forth. I bet 90% of the people here could spout off Miranda just like they were reading it off of a card. But it requires, as Tracy alluded to earlier, that you be in custody, and that if you are in custody and they're trying to ask you questions, then you need to be read the warnings. So when, in this case with Brendan, and in the West Memphis 3 case, Jesse Miskelly, who was also mentally challenged, lower intelligence and per his testing scores, and limited in his social abilities, so on and so forth. When they were originally looked at, they were both considered witnesses, not, they weren't considered to be, suspects. So police can talk to a witness without giving them any warnings whatsoever. It's almost impossible for a layperson to know at what point you're a suspect. And then, as you give this information, pretty soon you are a suspect. They have grounds to arrest you, and then they read you the warnings. And by then it's too late. So, if you're being questioned by police, most people aren't sophisticated enough to know, well, I'm just a suspect, and or I'm a witness. And the only simple way to take care of it is, hey, we'd like to ask you about whatever. And as Julie said, your response should be, well, we would like to talk to your daughter about this, or your son about that. They're just a witness. They're not in any kind of trouble. Well, that's could be a lie or it could be the truth. It's like, oh, absolutely, happy to cooperate, but we're going to need to get our lawyer over there. And you just have to stick to your guns because it's too complicated to understand for the typical layperson. When are you when are you in custody? So when you're put in the back of the police car, do you have to have handcuffs on? Because when do you ask, am I free to leave at any time? A lot of times they'll tell you you're free to leave at any time, and then they'll continue to ask questions until you've buried yourself. And so you're free to leave at any time. If you want to have an attorney, great. And then you bury yourself, and then you ask if you can go back to class to finish your project, and they say, no, it's going to be a couple extra days.
Travis, can I just put something in on what you just said? You're free to go at any time. like they said to Brendan, when he's sitting in the back of a police car on a highway, it's not like he was, you know, in the police station where he could just, you know,
And
go
obviously,
outside and his mom pick him up. Like
yeah,
they picked him up on the side of the road and
yeah,
were like,
obviously
you're free to leave at any time. Really?
the implication is that when we stop, you can go. You know, I mean, obviously it's not don't jump out of the car now, but yes, I understand what you're saying. It's like someone expect that they're free to go when you're driving down a freeway.
Right. And he's in the middle of the car. So of course they're still going to talk to him. He can't just walk away from the conversation. He's in a, that was so, it was manipulative is what
Right.
it was.
And that's why they had to read him his Miranda rights, because when you're in the back of the police car, you are in custody. So that's why they had to read him his Miranda rights because of that.
I'm sorry, Travis, for interrupting.
No, it's not. And so they'll tell people in a police station they're free to leave at any time. That, you know, that door's not locked. You can get up and leave at any time. But that's a reason why they're not doing their Miranda rights. But so, for example, if they come up and encounter you on a street and start asking questions, where you and you're clearly not under arrest, they just come up and start asking questions because they think you're a suspect in a sexual assault, let's say, that happened around the corner. You start, you know, where are you coming from? Where are you going? And maybe there's something you're embarrassed about. You're having an affair with a woman down the street. And so you say, well, I'm coming from this place. And they know it's a lie. And they, you know, now they have body cameras, so everything's recorded. So instead of being able to just say, well, you know, I'm not going to answer any questions without my attorney, you think it's so innocuous, but the next thing you know, you're getting hooked up as a suspect in a sexual assault case just because you had an untruthful answer about something. Miranda, I can't tell you how many times I've counted on a DWI arrest, for example. They're asked a bunch of questions as part of a DWI investigation. So you're in your car, seated, you're stopped, you've been stopped for speeding, let's say. They start off with, I smell the odor of an alcohol. You know, have you been drinking tonight? Yes. Well, how much have you had to drink? Where was it? When was it? Over what period of time? And if you voluntarily answer all of those questions, you're not under arrest. You're not in custody for constitutional purposes. All of that stuff comes in. Field sobriety tests. You know, they can't force you to do them, but very few people refuse to do them. And so you do the horizontal gaze nystagmus test. That's the pen in front of the eye. They have you do walk the line test. They have you stand on one foot for 30 seconds and count. And then they go ahead and arrest you at that point. They very rarely read you your rights. They put you in the back of the car. They want you to spontaneously talk on the ride to the jail. They won't ask you any questions, but you always see them asking questions. When can I get my car? Will I be able to get out tonight? And it's to, you know, get you talking so you can hear if your speech is slurred, for example. You're on camera. Look at your eyes, how your eyes look and your mannerisms. Frequently, you know, people get mad and start yelling and cussing and screaming and so on and so forth. But Miranda doesn't apply at all. They're not questioning you on the drive to the jail. Now, if they put you in an interrogation room and want to ask more questions, maybe about a hit and run driver a mile up the road from where you were arrested, and they come in and want to ask you questions at that point, if you were up on that road and whatnot, yeah, then they're going to have to Mirandize you and you get all of the warnings. But the questions about the field sobriety investigation and all of that, Miranda doesn't apply to any of that. You're not in custody. And it's knowing that you have the right to refuse to answer any question, whether you've been read rights or not. But the only thing you have to give, and it varies state by state, is your name and possibly show your ID. They need to be able to identify you. But in some states, they can't even do that. But, you know, it takes a certain amount of confidence in your understanding of the law to be able to say, when the next question is, okay, where are you coming from and where are you headed? To be able to say, I'm not going to answer any further questions. Am I under arrest? Am I free to go? But that's what you need to be able to do.
Okay, let's see. Oh, before we go to anything else, I just remembered I brought these up here. If anybody was on last night when I talked to my daughter, and we talked about her scholastic little Detective Academy books, I actually have them. Let me get my Hangouts room so I can actually see my video. Yes, I have them here. This was them. And there is Undercover Operations and Tracking and Surveillance and Crime Scene and Surveillance Photography. And I think this is the one that she had a lot of notes in, I think. And Forensic Analysis, and she got a little microscope to go with it. And then she got a little cassette recorder because it was because whatever's on the cover is what they sent her with it. Interviews and Interrogations. And then this one was Forgery and Frauds. So she got a little black light. So that was her. So now you know why this child is so into this, because this is what she wanted. This is what she wanted from the Scholastic bookstore when she was 9 years old. So yes, she is. She said she has known for a long time what she wanted to do. She was not exaggerating.
Jinxie wants you to PDF those for everybody.
I know, they are actually really interesting. I gotta tell you. I was flipping through them, and wait, let me just look quick. I should have looked at this one. Interviews and Interrogations. Let's see where they talk about the Miranda warning in here. They probably do. Interviewing a witness, detective jargon. Don't relax, get the facts. We throw little things in here. Yeah, but it's actually very informative. It actually tells you a lot about each topic. You know, now it's probably a little disturbing that my 9-year-old daughter was reading about forgery and frauds, but hey, you know, the more you know. So yeah, and this is the one where they had the fingerprinting kit, where she said, like, my mother was going to kill me with the fingerprinting powder. Yes, that was not a fun thing for a parent, but they are actually really interesting.
Miss Chris would like to know, and thank you, Scooby, for the donation. Miss Chris would like to know, after this, are you going to take a break from the live streams, or is this your new thing?
I can't see myself doing one without a reason for a while. I don't know what I might do one just as a short one afterward to talk about the donations. I don't really know. I don't want to say though. Yeah, I don't see myself doing one for a little while after this, but of course, if there was something that came out soon, then I probably would. But like if the judge's decision came out, maybe I would. But other than that, I don't want to talk to anybody for a while. And I'm sure you guys don't want to talk to me for a while.
Let me look at our current, because we only have, when are you?
I have 55 minutes left. I have less than an hour.
Okay, so we have 2,800 minus Thanks,
How many subscribers is, hey Stacy, how many subscribers is Stacy up to? I know we need to get Tracy and Stacy
Yes.
up to over 1,000 subscribers so that if they want to stream live from the rally, that's a new minimum requirement. Where are their subscriber numbers? Do we know?
Yes.
I'm at like 890 something or something like that. I need 100 more at least. And I have June, so hopefully I'll be able to.
We only need $8.81 to get to $2,800, you guys.
$2,800. I guess I should get the $3,000 out of my head, huh? Oh well, I was hoping.
Yeah, well, hey, $2,800 is, you guys are so awesome.
I know. I was trying to I was like, I can get to 3,000 by the end, but I think I ran out of steam. And I think I've actually soaked everybody dry at this point.
Okay, so Tracy has 893 subscribers. So she needs 107 more.
All right. Okay.
And I cannot see how many subscribers Stacy has. Maybe he can tell us.
Yeah, Stacy has them set private, so you can't tell.
Stacy says she's at 620. Thank you to all. So
he needs 380 more subscribers.
if you haven't yet subscribed to either of those, please do.
It's always interesting to me because even with the videos from yesterday, and I know I have over 1,000 views, and a few of my videos have close to 3,000 views, but nobody wants to subscribe. I don't understand it, but yeah, whatever. But if you'd like to, and I said it's just because when we're at the rally, I'm sure we're going to want to live stream, and and it'd be nice to be able to do it on YouTube. I can do it to my group if I need to. Thanks, Jinx. I can do it to my group if I need to, if necessary. But it would be nice, especially after MaM-a-thon, having so many people that are only on YouTube and aren't on Facebook. It would be nice to be able to do YouTube more.
Stacy, I'm looking at your YouTube page right now, and I do not. I am subscribed, but I don't see a subscriber count. This is for live stream and not for monetization.
Yes. I've already said that. I don't plan it. I'm not begging for subscribers so that I can monetize. Let's put it that way. I'm just asking because now YouTube has said you have to have 1,000 subscribers to able to stream using the app, which would mean my phone or whatever when I'm not taking my laptop to the rally. So that's the reason. So for anybody that wants to go say, oh, she's doing this to try to get money. No, I'm not. And even if I was, I'm going to put this out there right now. Even if I was, my daughter is a YouTuber. My daughter has more subscribers and more views than all the other YouTubers involved in making murder put together. I do her taxes. She's not getting rich off it. The amount of money that the YouTubers are making on this is negligible. I mean, it is just so, yeah, anybody that thinks that anybody's making a ton of money off of this, they're not. Like I said, my daughter has close to 100,000 subscribers. She has one video that has 11 million views. Unfortunately, that one, a lot of it was before she was monetized. So she did make some money on that one. I will admit, she made a good chunk of change on that one. Other than that, a few bucks a month. I mean, it's not that much.
Let me ask you a question. You may have already covered this. I know. I think you've put this out in the public. You spoke to Stephen recently about his enthusiasm for MaM-a-thon, what we're doing right now. You confirmed with him about he wants it to go on the canteen and that he may want to split part of that up for his trust. But when do you think you'll be able to speak to Stephen again to, let him know about the tremendous support and the, how well donations have been going, at least up to this point and whatnot? When do you think you'll be able to speak with him again?
Well, that's up to him. I mean, I told him to call me on Monday and I can give him an update. So, but that's up to him if he actually calls me. Otherwise, I'll probably send in a letter as well, just to make sure I have it in writing so he knows. But yeah, it's just a matter of, I told him, if you give me a call Monday, I can give you the updated total. I believe, I don't know if Mark gave him a total, but I know Mark updated him because Eric has actually played a video before of of Steve saying he heard that it was going well. So, I mean, a video, a recording of Steve saying it. He heard it was going well, and to thank everybody. So I think Mark must have told him that at least that, you know, it was going well. I don't know if he gave him an amount or not though.
Tracy, is it okay to link the link to your daughter's YouTube?
Oh gosh, it's not about anything like this.
It's nothing case related, you guys.
No, if you like anime and anime music, then yes, yeah, you can if you want.
Okay. I just wanted to make sure it was okay before I post it. My fiance is really into anime, and he is really super critical of everything in the universe, and he actually really liked it and subscribed to it, and he doesn't subscribe to anybody. So
yeah, and
then
when you do these anime songs, to me they sound so weird because it's definitely a style, and my daughter has such a pretty voice, and yet when she's screaming, I'm just like, oh no. Show tunes, they're prettier, but
right.
But people that are into this like her, you know. So
mm-hmm.
Tracy, so we know the rally's coming up June 15th. Is there a lot that you have to do in connection with that, or are things pretty much set for what you need to do and whatnot? Or
I'm not planning the rally. That's being planned by Christine, one of the admins for the family group, is the one that's actually in charge of it. And then obviously I know Carla is involved and everything, but there's not a whole lot that you have to do for the rally itself. All you have to do is essentially meet with the police, you know, department, just to make sure that you're all set with, you know, knowing where you have to be, and make sure there's no like you're not going to be causing a scene or causing any, you know, traffic disturbances or anything like that. You just got to talk to them about that. And I think that's really all that you have to do, because we don't need a permit because you're on the public sidewalk. So you don't need a permit to do it. So there's really not much involved. And my part of it, I just got to show up. I am like driving some people there, like that are coming to the airport and going up there. That's about it. That's the extent of what I need to do. I just need to show up. And yes, if you're in the Philly area and you are not able to come to Manitowoc, obviously we'd love everybody to come to Manitowoc. But if you can't make it and you're closer to Philly, Philly is actually doing a rally too the same day. Dawn, you can post the link if you want, Dawn, to your rally page. I just want people to show up in support of the guys. And I said, if they can't make it here, then I gather somewhere else that you can make it. That's great. I think I heard some people saying about some possible international ones as well.
Hey, Tracy.
Awesome.
Hi there, stranger.
Hello. Hey. All right.
Oh,
so
hi.
I figured I should come in and put on that clip for Trav.
Okay, yeah, I was going to mention that. I saw that you're back with that. So.
All right, hold on. Let me
Tracy,
do it.
I'm going to private message you a question.
I'll screen share it with you guys. All right, so there it is. Stephen's own words, folks.
I don't hear it.
You didn't hear it?
No.
Oh, you couldn't hear it because... Oh, hold on. Let me do it again.
You get your headphones in? I did that yesterday too.
Yeah, I put on my headphones so that you guys wouldn't be echoing through my mic. So now I gotta...
I did the same thing yesterday.
If not, I can post it. But
Nope, I got it though. Here it is.
This is Stephen Avery. I thank you for supporting the MaM-a-thon. I hear it's going very well. I'm grateful that you care so much about Brendan and me.
All right, that's Stephen there, courtesy of the HOD.
Yes, is Mark going to be on with Paul later to talk about his visit?
I do believe that he will be on with Paul later. I believe I'm supposed to be on with Paul as well.
Okay.
Hopefully we're going to have somebody else there, but I don't want to say anything yet.
Okay. But yeah, so Mark visited Steve yesterday. He also took Steve's mom to visit him, and so he was probably able to tell them then that things were going well. So that's good. So he's being updated.
The thing I uploaded yesterday that was at the end of your segment and at the beginning of Paul's was another one from the HOD And it's basically he was on his way to go see Steven, so he takes everybody on a little tour through kind of downtown Manitowoc there, and then out to Waupun.
Waupun. You people say it so weird. Waupun. Jackie, we end at 9 p.m. Central Standard Time tonight is when this whole thing ends, even though, yeah, I wish that wasn't the time, but that's how it's supposed to end.
We still need $8.81, you guys.
And
So
I've
we need $2,800.
And I've already scheduled an upload that will start 2 hours after MaM-a-thon ends. It's basically the first one's. It's just going to be a premiere of my conversation with TikTok on the kickoff segment. So it's going to be just my chat with him there. Following that is going to be the segment. I don't know if it'll follow tonight or if it'll follow tomorrow, but the next segment that we'll upload will be my conversation with John Farrak. And then because I'm just currently working on uploading that right now as a premiere for after MaM-a-thon. And then obviously I'm going to break out all the interesting segments. I think I'm going to break out Jinxie and Andy Newton because that was a really fun segment in the second one. So that's what I'm working on doing, just so there's a little, and I'm calling it Memories of MaM-a-thon, just so everybody can, gently ease out of this whole thing that we did here, instead of having to be like cold turkey, like,
with Mike's interview, and then with Taylor's interview, post my freak out, post me getting angry, meltdown. I want to do that, and I don't know how to do it yet, but I'll figure it out. And I want to post those so people can at least just watch.
All you need is the way I do it is I have a special software that allows me to do screen capture.
Well, it's Movavi. I have the same thing. So
you have Movavi? Okay, then you're set. You got it.
It works weird on my laptop because my screen resolution is weird, so it never matches up. So I might have to do it on my old laptop. We'll see. Oh. But yeah, I have the same thing, and that's what I would use too normally.
All right. Okay. There you go. That would do it.
Yeah.
I need to clarify something, and this was my misunderstanding. The YouTube channel that we linked for Tracy's daughter is not the daughter that was on last night.
Oh, yeah, it's a different daughter. My younger daughter.
Yes. I thought it was the same person. I thought Tracy only had one daughter, but I was wrong.
Yes, definitely.
My bad, Your Honor.
I have one. No, okay. It would be crazy if Taylor had time to do YouTubing on top of everything else.
Hey, you never know. You might be Wonder Woman.
Yeah, no. The youngest one is the singer that's into anime and YouTube and stuff, and the oldest one is the one that likes to work with dead people.
She likes to cut open dead people.
Yeah, she likes to cut open dead people. She thinks it's cool.
What's up, Travis?
What's that?
What's up, Travis?
Not too much.
Just thought I'd give you a chance to speak up.
I know I've been talking and not letting Travis talk. I'm sorry. I've been talking a lot.
That's why I let him have the Miranda question. I was like, poor Travis.
What can we say?
I'm sorry.
Usually it's hard to get a word in edgewise. Anyway, no.
We've done pretty well today, considering I had absolutely nothing planned, despite what the title says. I had nothing planned to talk to you today, and we've done pretty well filling the time.
And Eric Jose, we're only $8.81 away from reaching $2,800.
Yep, that's great.
And that was my segment goal, as we're calling it, $2,800. So $8 more.
$8.81, you guys. Come on.
Mm-hmm.
We can do it.
We can do this. We got it.
We're just all watching this.
I know we're watching the chat. Does anybody have any other questions?
I'm just going to take a break now. I only have 40 more minutes. I can do this. It is a long time. It is a long time to be on, but it goes pretty fast once you get talking about stuff. But
when you get to talk about stuff, yeah, it kind of starts to go by quick.
Yeah, that's right. I can't believe it's already been over 3 hours when I had nothing planned. We've managed to kill the time pretty quickly.
Right.
I don't think it was killing time. I think there's been some great stuff we've been talking about.
When you haven't slept and you're just like, how do I fill 4 hours of time? Yeah, you're happy to be killing time with something.
That's true.
I don't want to sit here and look and like every minute feels like an hour.
Mm-hmm.
If I didn't enjoy it, I wouldn't do this if I didn't enjoy it. It's just that it's like I was very concerned about a lot of dead air.
If you don't stay in the right mindset, you can like totally burn yourself out on the live. It's certainly it can happen. You just gotta like forget about that stupid clock. You gotta just like not look at it. You gotta just like somehow mentally block yourself from looking at the clock, and That's the trick.
That's why I was surprised when I looked and it was already 2 hours had already passed. I was really surprised that it went that fast.
Right.
Oh, I had the wrong screen open. I didn't see the donation. Yay!
I need like a
donation.
30 favor.
I think that Fen is updating our total right now. And Scooby just said, we were talking about this earlier, but absolutely, Marquette has about 11,000 students. I doubt they're all colluding. Well, she said, I doubt they is all colluding.
They all colluding.
Julie has, Respect Watcher has a question. How will Brendan be reintroduced into life on the outside?
A lot like the way they showed in the when they were trying to get him released when he was 12 hours from being released. They had a whole plan, probably something a lot like that.
Yeah, unfortunately, our prison system here does not really do much as far as offering services to help reintegrate prisoners. They do a little bit, but not enough. So yeah, I mean, hopefully the best you can hope for is that you have a good support system and that you can, have people to help you build your life again, because they will literally kick you out of prison with just what you came in with, and that's it. They don't particularly care.
Mm-hmm.
So, I mean, they do have a release fund. Like I said, that's why they do the release fund and keep that for you. And then Brendan would also have his canteen money. So he has that. But other than that, you think about somebody who doesn't have the support from so many people, like, that Brendan does, and how when and it's easy to see why people reoffend, because it's like they don't have anywhere to go. They have no resources. They have no money. They have no support. And the easiest thing for them to do is to reoffend, is to commit another crime and go back to prison.
Right.
And that, Steve and I have talked about that a lot, because that's one of the things about prison reform. He says that that's so common that people do that, because it's like, well, at least if they're in prison, they get a bed, they get meals, and when you're already a felon, you don't have many opportunities. So it's sad. And that's why we need prison reform on top of just criminal justice reform in general. Start helping these prisoners. The best part to get somebody to not reoffend is to give them the skills so that they won't feel like they have to.
Right.
Okay, so our goal, we're at $22,811.19.
You guys are awesome. We passed our goal. Thank you so much.
Oh, Angie's saying sometimes they go to minimum and get work release for a year or two before release, but it's not guaranteed. Yes, Angie's a prison. She would know. Just kidding. I'm not being mean. That's just our joke.
Zelma said, Tracy, once you said there are a lot of people who haven't seen Making a Murderer. I agree. Everyone I talked to about the case haven't seen. I feel so lonely around here.
It's shocking to me how many people haven't seen it. Even in Wisconsin, you'd think that they'd want to watch it just because it's in our state, if anything.
It's close to home.
And no, some people just said nobody in my family's watched it except for one person that I know of.
That's why I was so happy to find this community, because I was like, finally, there are people I can discuss the case with that are going to be like, Julie, will you shut up already about this case? I mean, I'm sure people here are telling me to shut up, but not shut up about the case.
I did not know 3.5 years later was going to lead to me being part of a live stream for 48 hours straight, but, being so involved. But, it happened.
Back when I got involved, it was much easier, because I went onto Facebook and there was like 50,000 people talking about Making a Murderer at any given time. And it was like that for pretty much 6 to 8 months. And then, it kind of all went into different communities, and it's kind of become kind of what it is now. And then some of that people have kind of dissipated and, gone on to other things or just lost interest or whatever. But then MAM-2 came out and we got a new blood rushed in. And so, it's good. There's a lot more people getting to the core people, though, that really care, the ones that stick around,
Right.
I've seen a lot of people commenting, especially today, that they have learned a lot about the case during this event that they didn't know previously. And I think that was part of one of the things that we wanted to achieve with the event. At least that's one of the things that Tracy mentioned when she came up with this idea. And I think it's great that people have learned, they have gotten information and knowledge from all of the great people that have talked over this event.
there's so many different places to go. Some people are just on Facebook. Some people hate Facebook and are only on Twitter. Some people, are only on Reddit. Some people don't like any of that stuff and just want to watch YouTube. So this is a way for everybody that has great information on all those platforms to come together and present it in one place, so that that now everybody can just watch a video, because everybody can watch YouTube. It's not that hard to watch a video. Maybe for 4 hours it's hard to watch a video, but it doesn't, you don't have to sign, or you don't have to create an account somewhere and then join a group and then scour through all these posts and everything,
Right.
or learn who do you have to follow on Twitter to get the good information. It's all just been right there in a little package, all weekend for people. So
Right.
I hope that's what's been helpful.
Mm-hmm.
So everybody thank Tracy for coming up with this event, and go and subscribe to her channel so she can live stream from Rally.
Julie, you just push it.
Well,
You're pretty close already.
yeah, she's
No, you
she's
need
really
Need
close.
112 more.
We need to help in any way we can, and you guys are all so awesome. I'm looking at this total, and I'm just like, oh look, we got even more. We got another one.
Another donation. Thank you.
You guys are so awesome. Your support for the guys is wonderful.
Honestly, I think if I didn't hit 100 by the end of this week, or 1,000 by the end of this weekend, I don't think it's going to happen.
Following up on something that Zelma said, Tracy, how many people, in like your part of Wisconsin, would you say have not seen either MAM?
Well, obviously I can't, I don't know what people are doing, but on my Facebook, I have 400 Facebook friends that probably live in Wisconsin. Obviously, most of my Facebook friends are in Wisconsin. And I remember about maybe 10 people posting about Making a Murder, and even less posting about Making a Murder 2. I saw maybe 3 posts from people about Making a Murder 2. And that's out of, like I said, about 400 people that I know in Wisconsin and that are on Facebook. So it's not a lot. And unfortunately, a few of the posts, 2 of the posts that I saw for Making a Murder 2 were not favorable. So, I said Wisconsin is a totally different experience than it is for anybody in any other state. When you talk about people about making a murder, it's a totally different thing here.
Yeah. Although I will say, when Mark and I were there last year, we got approached while we were having breakfast. There was this young couple who had kind of heard some of the things we had talked about, had some awareness while we were there, and actually approached us while we were eating breakfast. And it was actually great. We didn't even care that they were interrupting our breakfast. We were just like, oh, hey, how's it going? Da, da, da. They were like a young couple, and they were pretty enthusiastic, and they came over and sought us out. It was interesting. So I think and then I also had another couple that was messaging me on Messenger all day and caught me on Saturday just before I went back to the airport to catch my plane. But they came out to meet with me, and it seems like the young people there do have open minds, and that they are keen to support, or to, express that they don't like what they saw in MAM at the very least.
Right.
They're not comfortable that that's going on where they live.
Thank you, Aaron, for your donation. We just got another one.
Let's see. I'm trying to see if there's any questions in there.
Chorizo and eggs. Were you having chorizo and eggs?
Do not talk about food. I've had movie theater popcorn. That's only
today. I haven't, but it's become one of the catchphrases, I think. So
hashtag SausageGate. So we're at $2,845.19.
Okay, I have a half hour left. We can still get to 2,900.
We can. We're only $54.81 away.
Every time we have this final push, you guys push me over to where I start pushing to the next goal again.
Mm-hmm.
No, I am not kidding though. All I've eaten is popcorn all weekend, because I am the few times that I'm not busy doing something, I'm too tired to actually make anything.
That's why I ordered pizza.
I'm too tired to even eat anything. So I had leftover movie theater popcorn when we went to the movies Friday, and that's actually all I've eaten. And a beef stick.
Oh no.
I don't want to cook. I'm so tired.
So Haley says, I only recently watched MAM, could not shake the feeling of injustice. Any free time I have, I learn as much as possible about the case. Thank you to all you guys for your hard work. And that was one of Tracy's, that was her number one goal, was awareness. And so it doesn't matter how long you've been associated with the case, if you're just watching it for the first time, or if you end up watching it for the first time because of this, it's great. And thank you for that comment, Haley. It's nice to know that people who are just coming in are learning. And Eric Jose has talked about the cycles of people coming in and out. And, we try and bring everybody up to the same speed, old and new. Someone said they're hopeful for the new generation. Jackie Ree says, I'm counting on the younger generation in Wisconsin. And Tracy, is your daughter going to probably try and stay in Wisconsin as far as work in her field, or does she know yet?
Yes, she'll be in the Wisconsin area still.
So after seeing her, I'm very hopeful. I'm very hopeful. Yeah.
I had a laugh. I'm sorry, I was laughing because Julie's like, I was watching you while I had a pee.
I saw that too. And I saw you laughing at that.
Thank you for that commitment, Julie. We appreciate that level of commitment. I am not going to take to the bathroom when I pee while I have the video going. Just saying. I'm ruling that out.
Cindy said, thank you so much, Tracy, and everyone else. You all are amazing. You guys are amazing too. Like, this community is wonderful.
The community.
Awesome.
Everybody together.
Yes.
Makes it work.
It really is.
See, Sue's comment says, my teenage daughter heard this in the car and came home and is watching MaM now as we speak.
That is so great, Sue.
That's awesome.
Oh, that's awesome. That is cool. Hey, it sounds like we're reaching some people, which was really the main goal for me.
And you know what? Tracy was saying that last night when Taylor was on. At least I think you were saying this, Tracy, but it was when Taylor was on, and you were saying that, these people are leaving because they are they're retiring or whatever, but they're getting replaced with people who are younger, who are more educated.
Right.
And that's definitely a good thing.
Taylor had said that Wisconsin was one of the most highly on the list of states that are looking for MDIs right now. Like they're doing the most hires of MDIs right now, and that because so many people are retiring. And I said that's good news on two, for two reasons. One is a lot of people are retiring. Thank you, and that the new people coming in, they're actually advertising for trained MDIs, not just taking the cops and sending them to a seminar for a weekend. So you would get, and if anybody missed it yesterday, she got a job notice for Manitowoc County looking for an MDI as well. So I was like, that's the best news I've heard in a while, that Manitowoc County is actually thinking about getting an educated investigator.
Yeah, that would be great.
Yeah. So.
Teresa wants to know, Tracy, what will we all do when the guys get out?
Have a big party.
Yes.
What we would do is have a big party, tell them we're happy for them, and then let them lead their lives.
Yes. Thank you,
That's
Russell.
what we need to do. Just because we've supported them all this time doesn't give us the right to invade the rest of their lives. I know I can speak for Steve especially. Steve wants a quiet life. He really does.
I have no interest in invading their lives, but I intend to move on to other cases.
Right. Yeah. I'm not saying give up on anything. I'm just saying
yeah, no, that's the goal though. Yeah, I totally know what you mean, and I agree.
Is that they deserve to have some freedom and peace without all of a sudden feeling like they owe us something because we've been here for them all the time. I'm like, no, just tell them you're happy for them, and then let them live their lives and hopefully live their lives in peace.
Absolutely.
Yes.
We have another donation. Thank you, Russell.
Yes, we do. So what is let me look up what the total is now. I'm sure Finn will put
you're definitely going to invade. Dawn is allowed to invade.
So I'm about to head out on this, but I just wanted to let you know, Tracy, I wanted you to be ready around the last half hour of my live. I want to get all four of us all together on it. Hopefully if I can get Paul up that early. Anyway, because that'll be 9 o'clock Central Time. I don't know. Maybe I might not be able to get Paul there at that time, but as many of the hosts there for that final half hour as possible. So keep that in mind.
So no Game of Thrones, huh?
Game of Thrones can wait.
Oh,
Hey, look, if I got
It's not going
Game
anywhere.
of Thrones, then you gotta help. So anyway,
okay. Nobody better spoil that for me when we are in the chat. I swear to God, I will hunt down anybody that tries to spoil what happens.
no spoilers, folks. No spoilers.
No spoilers. That is just not classy.
Cool.
The fact of the matter is that let's see, I start. It's probably about 2 hours. 2 hours after I start, I think it actually, because we watch it through HBO Go, we get to see it at the same time as East Coast. So I'm gonna be like wanting to go watch it. Be like, this is proof how much I love these guys right here.
Let's get a game for like an hour and 20 minutes, and then come back and finish. No. We can wait.
Eric Jose,
Yeah.
Fen is asking if you will play Steven's clip one more time.
Yeah, sure.
She loves hearing it. While you're getting that ready, our current total is $2,857.61.
This is Stephen Avery. I thank you for supporting the MaM-a-thon. I hear it's going very well. I'm grateful that you care so much about Brendan and me.
All righty, there it was.
I love that. That's great.
It's great to hear Steven's, happy about it and great. It's
I wish Brendan could have called in. That would have been cool. Sorry.
No, yeah, no worries. So yeah, I mean, it is for him and Brendan. So it is nice to hear that he's aware of it and knows what's going on and everything, all that. So hey, I thought everybody else should know as well. So there you go.
That's awesome. Thanks for playing that.
Yes, thank you very much.
All righty. Well,
Me too,
I'll see you guys in a bit. I'm going to finish this little upload I'm working on with John Farrax a little bit, and obviously we'll see you guys later.
Okay.
See you
Bye.
Falls most likely too. Maybe I'll show up during Alley's too.
He's gonna make a cameo and everybody's
He's gonna make right.
Hey, it makes it more fun, right? It's flavor. Anyway, all right. Bye, guys.
Later.
Bye. It does matter. It really matters. To quote Stacy Seabrook, it really matters.
Okay, so we have a little over 20 minutes, and we need $43
to get to 2,900. If we can get $143
know,
and get to 3,000, I would donate it if I could.
I would too.
Just so that we'd have it.
Yeah, no, it's fine, Eric. They don't. That I think it's fine here. Yeah, I know. I remember that Adon got in trouble for that, but
why would they get in trouble if they are consenting to it? Like, I don't understand why they would.
Some prisons have that rule. The only rule that the prison has is no third party phone calls. So you can't he can't call you and then you call somebody else so he can talk to somebody else. Yeah, right. That's the only thing that there is a rule against.
Okay, I understand.
Haley's going to the presentation in London with Laura, Stephen, Dean, and Jerry, June 8th.
Very nice. That's exciting.
I don't know as I've seen Dean and Jerry out on tour for a while, so that's really lucky to get the four of them together.
Oh, Carla, sure. You show up for the last 20 minutes. It's really a good thing. My stomach keeps growling. Just thought everyone should know. I'm starving. Send me a pizza, thanks.
Oh, hi, Carla.
Yeah, that's what I said. She shows up for the last 20 minutes.
Yeah.
Whatever. Okay, so
I'll have to say Julie Gerard has got to be my vote for one of the most devoted watchers. She doesn't let anything interrupt her video or audio feed.
Okay, next is Paul. I'll post a link to the next video so you can have it ready. Don't leave yet, though.
You can tell I'm getting uncomfortable because I've done this like 3 times now. It's like my neck is killing me from this dumb chair. Like I've changed positions like 10 times in a minute. You can tell I'm getting restless.
Here's a link to the next segment, but don't leave yet. Just
Yeah,
like open it in a new tab and wait.
Not till we hit the $2,900. Then you can leave.
No, you can leave when we hit 3,000.
Okay. Julie's just holding you hostage here for the entire time.
Well, shoot for the moon.
Yeah, that's what I said. I said, might as well ask, for more. And if you don't get it, fine, then ask for 2 little.
And you know what? If you can't donate, I don't want to be like, if you don't donate, shame on you. I don't even want to make it sound like that at all. This is so amazing, and the donations that we've raised are amazing, but we want to encourage it as much as possible because it's really going to help them out.
Right. And if you can't donate, that is understandable. And not everybody can, not everybody's in the position to do so. And so then we just ask, spread the word when you can. That is,
it came up as my channel.
That's a big help too. How much to get to 3K? Eric is asking. We're 140. Did we say 143?
$143. I'm gonna
3K.
Repost. Who was saying it came up as my channel? I missed it. Jackie. Okay, here, Jackie. Try this one. See if that works instead.
We got a donation.
We did?
Stand by. That's right, Andy. You're on vacation. Whatever. I don't want to talk to you. You missed
Eric.
It. Eric, is that you?
No. It's not.
Oh.
I'm gonna wait for, well, I guess Fen can add it and I can tell everybody what it is. We got a donation from Mr. Stacy Seabrook. Please go and subscribe to his channel.
Yes, please go subscribe to Stacy.
I will post the link right now while Fen updates our total. There's his channel. Thank you to everybody who has donated. Thank you, Stacy. And as soon as Fen updates that, then we can, let me check the
suspense.
Oh my gosh, we're so close. Let me look at the GoFundMe really quick before I say anything. Oh my gosh, Kimberly. Oh my gosh, you guys, please stand. Please hold.
Please hold.
Please continue to hold. I'm channeling.
You guys are just killing
reporting life for my sofa, Paul.
I'm gonna get all weepy and teary-eyed from being tired and hungry and emotional.
You guys are, oh my gosh, this is so cool.
If a new trial is granted, do you believe a change in venue will be needed, or can SA get a fair trial in Wisconsin? I think he has a better chance now than he did last time. That's for sure. I don't really know what they'll do. It's going to be up to what what Kathleen would want to do. It's going to be strategy.
So we
I see it.
Yes, we are over $3,000. Thank you so much, Kimberly, for that generous, awesome donation. 3,057. Oh, yes.
Thank you so much. You too. Again, go subscribe to Stacy's YouTube channel. He needs subscribers. He can play music for us at the rally.
Yes. Oh my gosh, you guys are so awesome. I have tears in my eyes right now, and it burns because I have makeup on.
Emotional. $3,000, you guys. That's amazing. And we have 8 hours to go. 8 hours.
Oh my God, I love you guys so much. You guys are so great.
It feels so good to be able to just do something that can do something for them. Because I know it's, there's not much we can do.
It's live, Scooby.
So if Brendan can watch a bunch of more movies, which he loves to do, that will make me happy. Hearing from him like how he loved this movie he watched means the world to me. So yeah. So if we have to help to get money so that he can watch a damn movie, that makes him happy, then yes, this is why it's worth it. And thank you so much for helping out with that.
Thank you, everybody, so much for your donations. You're so awesome.
What, Carla? Why are you calling me now?
Oh, Scooby had a comment. She said, Mr. Buting suggested when I talked to him that they thought Stephen might get some sympathy because he was wrongfully convicted. Did somebody else already read this? Before in the same area. I don't think he knew the local climate. I know Tracy's on the phone, but Travis, did somebody else already read that? Did I miss that?
Let's see. I saw some things from Scooby that she sent to me. She was talking about Madison and Milwaukee, but I thought it was in a different context.
Travis started answering a question.
No one, I don't. They were aware. They were aware of the area. You know, it's. They tried to move. We talked about this earlier. They tried to change venue. The best they got was just getting it out of Manitowoc County over to Calumet, but with a Manitowoc jury.
Wait, hold on. I'm going to have to just interrupt you for a second because I actually have Carla on the phone. She was calling in to say hi. So that's why I was like, I didn't know how long this was going to be. And she's just sitting there waiting. So everybody, if you want to say hi to Carla, say hi to everyone.
Hello, everybody.
Sorry, Travis. Off. I just wanted to put her on.
Well, I just figured I'd call and thank everybody that's helping the guys out. I've been on and off for the last couple hours, but yeah, I figured I'd appear.
I'm sure everybody would like to know how are Grandma and Grandpa doing?
Oh, they are doing excellent. They're taking things one day at a time. Their health is actually pretty good right now. Dolores may have to put Bandit down because he's not doing the greatest, but of course we're going to be there for her when that has to happen.
Oh my goodness.
Yeah.
Oh gosh, that's so sad.
Yeah. As a lot of people know, Bandit's for life.
Yes, that is her constant companion. I'm going to cry just thinking about that.
Deep breaths.
That is. I mean, I've seen her with Bandit, and yeah, that's going to be so hard. Okay. Anyway, go on. I'm gonna power through.
But yeah, Bandit's pretty rough. Things are starting to shut down, and while he's 14 or 15 years old now, so we knew it was coming, but all we can do is be there for her when we do have to put him down. She's been trying to postpone, and we've been trying to talk to her, and we might be doing that this next week.
Well, we'll be saying some prayers for her for sure.
Oh yeah, but otherwise, Mom and Pa are doing real good. Grandpa Al's still going up north every weekend. Now he's starting to plant his gardens, and yeah.
That's good to hear.
But Brendan also wanted to say thank you to everybody that's doing this. I haven't been able to get a recording. He's only allowed 3 calls at the new facility. But I did go down by him the other day, and we talked about it, and he wanted to thank everybody for that. So, and he's getting a visit from Pete and Lori today, so he'll be happy.
Yeah, he will. He's looking forward to. Yeah, I know he looked forward to your visit when you were there last time, and it's nice that he's closer, so that everybody can see him. And it's really nice. That's the best thing is that you guys get to sit and have a meal together. And I don't think people realize what a big deal it is when you haven't been able to sit and have a meal with someone for 13 years, and you do, you get to. And he said he was excited. What did you say? Because he had lasagna, and he was so excited that he got to have lasagna.
Yeah, they actually had lasagna for a meal last week sometime, and he says he doesn't remember the last time he had it, and he can't wait for it again.
That's
cool.
Yeah, the other day he wanted to try the shrimp and steak, and I don't know where he put it, and he doesn't know either, but
he ate it all, and that's exactly what I was talking about when helping them with the canteen. That means he can have those little moments of things. He can buy a steak for a dinner. He can buy and that's what everybody's helping out with, just to give him those small things. To hear somebody say that I was so excited to have lasagna, we take that for granted. We can have our whenever we want, and so to hear that's why I said it's for us. It seems like such a small thing, but for him, it's huge. It's a huge deal.
Oh yeah, yeah, it is. You know, and the prices aren't that bad, but you know, it's the thought behind it. He's having almost like a restaurant style meal because you have other inmates that actually are learning to be a chef. These inmates are actually making the meals for the other inmates and the families.
That's so cool.
And yeah, he's enjoying. Oh, I don't know what I'm going to have this week, but let's try this and that.
Yeah.
Can he get French fries?
Yeah, he did have fries, didn't he? I think he had fries.
Oh yeah, he had fries with both. The steak came with fries, and so did the shrimp.
And he had chicken nuggets, right?
I want some French fries.
No, he was going to have the chicken nuggets this last time, but he decided not to. He'll get them next time. He's glad he did.
Yeah, he wanted steak and shrimp and fries and ice cream.
Yeah.
And he wasn't getting.
Next week, I think he said he's going to have just the salad. He's going to try this big ass salad that they have. Sorry.
Yeah, but he wasn't getting food like that, you know, in Columbia when he was at Columbia.
No,
for sure.
No, only vending machines, and it's nice not to have the vending machine anymore. You know,
right.
but on the weekends when we go or whatever, you only have soda as an option. You know, so you got to try to work around his meals, but he also can actually put a meal on hold. If he knows ahead of time that he's going to have a visit, he'll sit there and say, please hold a tray for me, and he can eat when he gets back, which is nice because at Columbia, if you miss your meal,
you miss your meal.
Till the next one.
Yeah. Yeah. So what was I say? So when people are asking like why is the canteen important? This is why. So Brendan can do things like that because he needs to pay for it with his canteen money. So this is exactly why we're doing this, so he can do that kind of thing.
Yes.
And all you people who have donated are so amazing. And on behalf of Brendan, thank you. And Carla, thank you for coming on and telling us this stuff. This is important. I think this is great for everybody to hear.
Everybody has paid a part in bringing a little bit of joy to Brendan's life when he really doesn't have a lot of reason to be joyful, but yet everybody has played a part in bringing a little bit of happiness to him. So thank you for that.
We really do.
I figured I'd get on and thank everybody too, because it helps them out, and he looks forward to these meals now. I got an email the other day. So, which day during the week are you coming next week? I'm like, well,
because he wants to plan what he's going to eat.
Pretty much, because Tuesdays and Thursdays you have more of the dinner options, the steak, the shrimp, the burgers, salads, and things like that. But on Wednesdays it's more of a breakfast menu. You get like a Denver omelet or pancakes, French toast. So. Oh yeah, he looks forward to it ahead of time. So.
I'm sure he does. It's a big switch. Okay, well, thanks for calling in, and I'm going to have to wrap it up in a few minutes anyway. So I really appreciate you calling and giving everyone an update. I think everyone loves to hear that Brendan is doing well, especially with the move and everything. So thank you for calling in and giving an update on MaM-a-thon.
Yes.
Oh yeah, sounds good. And anybody can message and ask anytime. Oh. Okay,
Thank you, Carla, for that update. It's really good to hear.
For doing this.
You are very welcome. We're happy to do it for you guys, or for the guys, but I mean for your family in general. So, okay, then I will talk to you later. Okay, bye.
Signing off.
Signing off. So there you go. So that was really nice to get an update, and so you can hear for yourself like how Brendan is doing, and that he is really liking some of these things that he did not have at the other prison. You know, it's not obviously like being free, but you know, to have French fries, you know, or to have like I said, lasagna that he wasn't able to have for so long. Oh my gosh, Dawn, that's right. When are you going to be here? You're coming this Thursday? You're going to be here this Thursday already? Oh my goodness. Dawn is going to be here too. Okay. She'll be coming to visit Brendan. So that's awesome. And then, yeah, you heard Dolores, they're doing okay. Al is, if you couldn't hear very well, Al is getting his garden ready, which if you remember from Making a Murder, Al loves his garden.
Mm-hmm.
He's doing that. And the only thing that makes me sad is about Dolores having to put her dog down. Bandit is a little chihuahua. And Bandit is her her companion, always with her everywhere. So it is going to be very hard for her to lose him. But he is like 15 years old. So that was very sad to hear.
We got another donation. I don't think I said it, from Haley. Thank you.
Thank you, Haley. Oh, Dawn. Okay, I
Pleasure.
thought we were coming to the end of the month. I got confused when you said Thursday. Sure. Yeah, Jinx, go ahead and do that. Yeah.
You should. I've seen pictures of them in Discord, I think. You posted them in the art room.
Yeah, poor Ma Avery. Yeah, that made me very sad. It was a very good update other than that.
Yes.
So we only have a few more minutes. So I feel like, I mean, I want to thank everybody again, but I know I've thanked everybody to probably shut up already. You're welcome. Be quiet. Thank you again. We're still going to be around, or, collectively, we're still going on until 9 o'clock tonight. That's 8 more hours for everybody in the different time zones. Just add 8 to whatever time it is now. And, join in with everybody else. I think we're going to Paul's channel next, correct?
Yes. And let me share the link again to Paul's channel. Sue Jones says, before you sign off, Tracy, I think you and Pom Pom and Travis have done a great job. I have really enjoyed it. Thank you, Sue.
I know that Eric Hosey he said he's got a jam-packed schedule tonight, so he's going to have a lot of great guests on tonight. I think he's going to have some music from Brandon Maddox is going to be on. I don't know if I think Stacy's going to be on tonight as well, and some other guests. So we're going to hopefully end it with a bang, and we will all be on at around 8:30 to give a final goodbye to everyone. Not that you're never going to see us again or anything. It's not like till next year, but still, just to kind of wrap it up. So. Yeah,
no, it'll be a good night. Go get some sleep.
Yeah.
That's
everybody for 2 days. Yeah. Don't look for any of us for 2 days. Like, don't send us any messages. Nothing. We're gonna be sleeping.
Look, Jim showed up at the end again.
Oh, he was actually just alive yesterday, and he always does that. Yo.
I'm
gonna call you Rocky. Yo.
So Tracy, I think I speak for everybody that glad you got a well-deserved break and rest, but we are really, really glad to see you back on. And sounds like from what you've been hinting about that even though it may not be as often, that you're going to be on basically a lawyer doing videos and answering questions right away. But it's just really, really nice to have you back.
Thank you. And it'll be good to be back. I still gotta kind of ease my way back into doing the group stuff, but I'll get there eventually. And I just saw a question. What was the question I saw?
How long?
I thought there was another question or another thing that I wanted to address. And how long is the donation email good for? A couple people have asked if we can wait till Monday, so I will plan on making the donation on Tuesday for the guys. So if you can so Monday night, by end of Monday night, or before Tuesday morning, at least if you're still wanting to donate before Tuesday morning. So then it will be sometime Tuesday, then I'll make the donation, or first donation, because you can only donate $300 a day.
Travis, Eric Jose just popped into the chat and asked us, said that we should tell you that you should be there to help close out the MaM-a-thon tonight at 8:30. Travis?
Oh, okay.
I'd be honored. That must have been what he was talking about with Tracy about at 8:30 Central Time.
Right.
Yes.
Is that right?
Mm-hmm.
And I should say
I'd be honored to.
Yeah, that's great. Yeah, that's great. So I was just gonna I was gonna add something and I changed my mind. So never mind. But yes, Travis, come join us. Everybody could try to. Everybody just wait to watch Game of Thrones, okay? Just watch it until after MaM-a-thon. And then just come and say goodbye or whatever. But yeah, stick around until then as much as you can. Go to the other channels, subscribe to everyone's channels. Hope you enjoy the guests. And and then Paul, are you ready to go? Are you up and running?
His stream hasn't started yet. It says waiting.
Oh, there, Fen just posted the link, so.
Yeah, I posted the link too, but I didn't say what it was a link to. I'm sorry. No,
Okay.
that was my bad. I need to do that. Otherwise, people are like, what is this?
Just let me know when Paul's up, and then I can
Okay.
sign off. I said we're not going to have any dead air, so I'm going to sit here until Paul is ready.
He says,
It
in
looks like he is
response to the
live now.
question, "Are you up and ready?" He responded, "Yup."
Yep, he is ready. There we go. Paula is live.
Okay, well then, thank you everybody again. I love you all for helping out, and enjoy the rest of MaM-a-thon, and I will see you at the ending show tonight. Thanks again to Julie for helping out. Thanks, Fen. Linda was here too, helping out. Angie's here. So thank you very much, you guys, for everything. And thanks to Travis, of course. I always forget. I just expect Travis to be my sidekick. So, so thanks to Travis too. We'll see you guys later.
Bye, everybody.
Bye, everybody. Thank you, Tracy. No thanks needed. It's an honor to be your sidekick.
Well, thank you.
Okay, I'm going to